Yes.
Maybe Lordship. Okay, I am praying for listing the matter tomorrow, Lordship. The bail hearing matter, Lordship. It was listed on 8/1, Lordship, but due to health issue of the Honorable Court, Lordship, it could not be taken up, Lordship. Petitioner is behind the bar, Lordship. Tomorrow, Lordship. CD is here, Lordship.
Okay.
Obliged, Lordship.
May I please? I'm praying for listing of a case for orders after vacation on 20.
May I please, Lordship, I beg for listing of a bail application. It was filed yesterday and the statutory period will be over on Sunday. So kindly matter be listed tomorrow.
Tomorrow we have lot of matters.
The petitioner is behind the bars since 87 days.
So for tomorrow.
Yes, Lordship.
Okay. Okay.
Much obliged.
Lordship, item number 11, the matter is of urgent nature, but due to sudden illness of the conducting counsel, he could not appear before this honor.
Who is the conducting counsel?
DK Bodyo. The matter
Okay,
may be
on the
fixed day after
on the pair being made by Mr. What is your name?
F. Amin.
F.
Amin.
F. Amin, learned counsel for the applicant. List the matter. When?
Day after tomorrow, Friday.
Friday.
No.
Friday.
No, holiday.
Okay, good. Then tomorrow.
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 Okay. Okay. Yes. Next.
Your Honor, items 7 and 8 may be taken up at 2 o'clock because it's clashing with another court. This is another matter coming at the same time.
Okay.
7, 8.
May I please, Your Lordship? I'm praying for listing, Lordship. The matter was listed on 8th, Lordship. 8th of January, Lordship. Due to the matter was deferred, Lordship. So matter may be tomorrow.
Tomorrow.
Tomorrow. City is available, Lordship. City is available.
Is it urgent?
There is no interim, Lordship. And there is some students, Lordship, and the 4 person.
Okay. Tomorrow we will try.
Yeah, please, Lordship. I beg to mention one, my lord, motion item, my lord, criminal petition for 12, my lord. Against my lord, a non-bailable working, my lord. Police is after me. So on 12.
So
my lord.
12, we have lot of matters.
My lord,
Only
motion.
after vacation.
My lord, police after me, my lord,
No.
because non-bailable warrant is
No.
pending, my lord. Kindly, my lord.
When the non-bailable warrant of arrest was issued?
My lord, on my lord, 12, my lord. This is 26, my lord, 26, 12, my lord.
No.
Only, my lord,
After vacation, no.
police visiting my house.
No,
Kindly, my
no,
lord,
no.
motion, my lord.
We have our limitation.
On 22.
After vacation.
Petition, Lord, I am listing for a criminal petition, my lord,
When?
tomorrow.
Not possible. Only after vacation.
On 22.
For listing of the bail application, that will be listed by day after tomorrow, but day after tomorrow I will be out of station also. So can it be taken up tomorrow also, if possible?
Tomorrow, how many matters?
Before vacation, there will be other benches also.
Pardon?
Before vacation, there will be other benches also. Maybe it will be distributed among other.
Okay, okay.
Obliged. The Lordship, I'm praying for listing of an anticipatory bail tomorrow, Your Lordship.
When?
Tomorrow, Your Lordship.
Tomorrow, tomorrow we have already more than 50 matters.
Fresh motion.
Okay.
Please, Lordship. I beg to mention the listing of anticipatory bail, Lordship.
When?
On Friday, Lordship. It was last listed on 8. But you
Friday not possible.
tomorrow.
Tomorrow also not possible. We have more than 50 matters already.
On 18.
18 immediately after reopening. 18th.
May I please, the Lordship? Your Lordship, I am praying for listing of a criminal appeal matter along with an IA connected for bail. Your lordship, on the last occasion, the LCR was called for.
When do you want?
Maybe on the 12th,
Not possible.
on the 18th or 19th, your lordship,
On 22nd.
22nd. Obliged, your lordship.
May I please, your lordship, lordship beg to mention for listing of a motion matter on 19th.
19. Okay.
Much. 22nd.
Okay, 19.
19 is okay. Much appreciated.
May I please, your lordship? So I beg to mention item number 37 of daily dispatches. So personal difficulty of my senior lordship, I beg
37.
37 for external.
On the appear being made by Mr.
B. Borgunhai.
City,
Learned Counsel for the applicant.
case diary not received, lordship.
List the matter when? Covered?
25.
25.
Lordship.
On that day, learned additional petition produced the case hearing before the court.
25. 25.
My please, your lordship. Lordship, my prayer for listing for motion, your lordship, a 439 application, lordship. Lasted 2 months, your lordship, maybe kindly on Thursday or Friday, your lordship.
Not possible.
439, your lordship.
Not
Friday.
possible, but we may fix it on 12. If some other courts, it may be listed before some other court also.
Lordship. 12, your lordship.
Okay. Okay. 12 or below court depending.
Lordship, another prayer, your lordship, item 38, your lordship.
Yes,
I think CD not received, your lordship. CD may kindly call for you.
yes, madam.
30th CD not received, lordship.
I am on interim, your lordship.
Okay, on the pair being made by Mr. A.A.R. Karim, learned counsel for the applicant, list the matter on, sorry,
On 29.
29. On that day, learned additional PP shall produce the case diary before the court. Until then, interim order passed earlier shall continue.
Wait, your I beg to mention for listing of anticipatory bail application tomorrow. Lordship, similar matters have been fixed for tomorrow, lordship.
We have already more than 55 matters now.
Lordship, in this case,
Tomorrow.
what happened? She's already in interim in one of the cases.
No, even then we have to peruse the record. We have to hear you.
Yes, lordship,
Where is the
tomorrow,
time?
Similar cases, the same PS case diary is fixed for tomorrow.
Maybe in similar cases also we have to hear you.
Yes, lordship.
Can we pass the order without hearing you and without going to the record?
This person, lordship, she is a bona fide purchaser of a land.
We are not supposed to hear you today.
Tomorrow, 3 of the cases, similar cases.
Maybe on 12.
12.
Lordship, in this case, lordship, case diary has already been called for.
Yes, case diary will be retained till 12.
Lordship, for listing of a IA lordship, your lordship, his warrant has been issued, your lordship, on Friday, your lordship.
Not possible. Friday, not possible.
On 18th, your lordship.
18, yes, 18.
Obliged, your lordship.
Wait, please, your lordship. Lordship, I pray for listing of a criminal petition on 20th, after the case.
Okay.
Much obliged.
May please, your lordship. I beg to mention for listing for anticipatory bail, lordship. It's second time application. It's a long pending lordship matter.
Okay,
So
after
kindly
vacation?
Tomorrow.
After vacation, not possible. Before
18,
this. Pardon?
18.
Okay.
May it please, your lordship. Lordship, this is an AB, your lordship. I'm praying for listing tomorrow because your lordship matters pertaining to the same PS is listed tomorrow as item number 42.
Not possible.
Your lordship, case diary.
Not
is called for.
possible.
Case diary has been called for
Okay,
tomorrow.
case diary will retain. They will retain the case diary.
Then your lordship on Friday, your lordship. This
Okay,
was
Friday.
obliged.
May I please, your lordship, this is a mention for listing anticipatory bill for Friday, madam.
Covid?
Friday, madam.
Covid, you confirm it from the section. Okay.
Obliged, madam.
May I plead your lordship? Your lordship, I beg to mention I criminal number 295 in criminal appeal 127 of 23. Lordship, this was last posted on your lordship 9/11/2023, your lordship. So kindly it may be listed on 12/1/23, lordship.
After vacation.
No, 18, your lordship.
May I please, for listing of the bail, I have filed in Monday lawsuit, then custody lawsuit. So on Friday.
After vacation.
Friday lawsuit, friendly lawsuit.
Friday, provided some other courts are also allotted the bail matters.
Okay.
Otherwise, it will not be possible.
Please, Your Lordship, I beg to mention for withdrawal of bail application number 50/2024. May it kindly listed tomorrow. Listed
Tomorrow. Okay.
Please, Your Honor, I beg to mention item number 31. The senior counsel have some personal difficulty.
Whether the case diary is available?
Yes, there is there, Lordship.
Who is your senior counsel?
Satan Sharma,
What is your name?
C Talukdar.
On the pair being made by Mr. C. Talukdar, learned counsel for the applicant, list the matter accused, list the matter on when?
18 or 19.
19.
19 January.
19
Okay,
January.
till then case diary will be written.
Lordship.
Weekly obliged. May I please, Your Lordship? Also, I am praying for listing of a criminal petition on 18th
Okay.
obliged.
Items from daily list, item number 1 for withdrawal.
May I please, Your Lordship?
Yes.
Lordship, I may be allowed to withdraw this petition.
Why?
Lordship, this matter pertains to, this is for the recalling of a production warrant.
Yes.
And the matter relates to NIA. And already the major amount has been paid. So by tomorrow or day after, they are going to pay the remaining amount and the matter will become infractions.
Acha.
Already out of
Mr.
12 lakhs,
S.N. Tamale, learned counsel for the petitioner, submits that he has the instruction to withdraw this petition. There is accordingly allowed, this criminal petition stands disposed of on withdrawal.
much okay.
Item number 2 for motion bail application.
May I please, Your Lord?
Mhm.
The matter relates to 439 application matter.
Mm.
My lord, I take you, Lord, the FIR that is at page 11, my lord. The WT message of the by forest in charge. My lord, these two persons were arrested now 57 days, 53 days behind the bar, my lord. All the sections are, my lord, relates to the violation or entry to the forest area, my lord, wildlife area. And my lord, they're actually tea garden labor, my lord. They are coming from forest areas. And at that time, on suspicion, they were caught, my lord.
Lordship, in this case, wildlife, forest.
Wildlife section, all are, but maximum punishment 3 years, my lord.
Lordship, then there is a standing council, Lordship, for forest.
Who is standing counsel?
Lordship.
Mr. Gogoi. Dixit
One
Gogoi.
is Lordship, B sir, Dixit Lordship. Bankim Sharma.
Can you inform him?
Lordship,
Mr. Biswas, after some time,
Obliged.
let the other side.
Yes, ma'am.
Item number 3.
May I please, Lord?
Yes.
Very difficult, Your Lordship. On 4th of January, Lordship has rejected the affidavit. Year before this, Lordship on after by this application. Two legal aspects that were not canvassed, unfortunately, before my Lord on the last occasion. That I am allowed to be asked before the Honorable Court. Before that, the Lordship, may I allowed to place some materials before the Honorable Court for reconsideration. Lordship order, Lordship is page 24. My Lord order dated 4th of January 2023. After
Yes.
perusal of the case diary, the bail application was rejected.
Yes, what is the ground for filing this second
Yes.
application?
Yes.
Yes.
And that is, before that, you know, to arch, there are two law points before your Lordship.
Mm.
I have to place some material before the Honorable Court.
Mm.
Lordship, can we have a look at page 27?
Mm.
That is a case registered initially as cyber PS case number 12 of 2023 on 2nd of November 2023. on the allegation that there is some forgery you committed at Dispur Revenue Circle in respect of the mutation of particular land, plot of land. So therefore, that case was registered on the basis of an FIR lodged by the circle officer of Dispur Revenue Circle.
Hmm.
What is important to note, Your Lordship, that the investigation officer is the Inspector Chandan Das in the said case.
Hmm.
Lordship will find at page 28, the IO was designated, he is the Inspector Chandan Das. Now, secondly, I have to also place before the Honorable Court. Lordship, kindly have a look at page 35. That is the forwarding of one Mr. Moinul Haq. Why I am pressing upon this? Because on the basis of the statement of Moinul Haq, I was arrested subsequently in another. Lordship, I have a, please kindly have a look at forwarding report. That is 22/11/2023 at page 35.
35. Yes.
Lordship will find the grounds of police custody as stated in page 36. He is the main persons as alleged by the police who has managed to get the mutation order. The arrested may be granted 10 days police custody to root out the whole racket involved accused person in fact mutation of land, to know the details of other accomplices. 3, to know the details of involved accused Monrava, Aman Ali, and Ashiruddin who are involved in illegal transfer. So therefore, he was arrested, remanded to the police custody. Now, this was done on 22nd of November. I moved a bail application before this Honorable Court on 28th of November. A pre-arrest bail. Lordship will find at page 38. And I take the indulgence of the court to have request this Honorable Court to look into at page 39. The observation and coordinate bench of this Honorable Court, page 39, Lordship. Peruse the materials available in the court and the allegation made in the affair, considering the fact that the petitioner is not named and the petitioner has taken a specific stand that the petitioner, being an advocate, on instruction from his client, applied for the certified copy of mutation order, which is alleged to have been fraudulently manufactured, and that he himself has intimated his client regarding non-existence of such mutation order. This court is the view that the statement of the petitioner shall be required to be recorded for further investigation, though may not be custodial interrogation at this stage. This court
No,
also
Mr. Dutta, this cyber PS case number 12 of 2023 and the present case are two different.
Yes, that is the point of what I would like to place before this Honorable Court. The cyber PS is the main case upon which the investigation has been take motion. And the crime branch case, that is the outcome of that cyber PS case. And Lordship will find in crime branch case, the subject matter is the reference has been made to cyber PS case 12. And it has been referred in the affair that during the investigation of cyber case 12, this case has been arising out of. And Lordship, the interesting aspect is that the Chandan Das, who was the investigation officer of the earlier case, in the second affair, he is the complainant, before whom I made a statement on 2nd of December when I directed by this Honorable Court. Now, my respectful submission before this Honorable Court is that the second affair is heated by section 162 of the CRPC. It is a part of the first case. And therefore, I would like to place the judgment of Honorable Supreme Court, Your Lordship, if Your Lordship allows it. Because my respectful
second FIR.
yes, Lord.
Second FIR means which FIR?
The first FIR is cyber case. Now is a on the same transaction, on the same subject matter of dispute revenue circle of different mutation, forgery of different mutation cases. And in the crime branch case, Your Lordship, in the first paragraph of the FIR, Lordship will find it page 14 of the crime branch case, wherein I am arrested on 12th of December. Your Lordship. Lordship, kindly have a look at page 14. With reference to, I have the honor to state, during investigation of the above mentioned case. Now, whatever the information received during investigation, that is a cognizable offense. And that cognizable offense, whatever the information, that is a part of the earlier first FIR. I may be arrested in the first case after placing the materials before this honorable court in my AB case. The yes, custodial interrogation is required. But my arrest in the second case, Your Lordship, prima facie, is not, in my respectful submission, not proper.
Okay, we will examine the matter. Let the city come. The meantime.
Up to date, City Lordship.
Yes.
And Lordship, second point is, Lordship may kindly consider another aspect, that I am arrested on the basis of the statement by Moinul Haq. Lordship, kindly have applied for a moment, have a look into my forwarding report. Forwarding report is page 19.
Yes.
Lordship, kindly have a look at page 20. Why I am arrested? Third paragraph. Third paragraph. During investigation, it is learned that one case has been registered cyber such and such. In that case, one advocacy, Moinul Haq, already arrested by investigation officer. During interrogation, accused Mohammad Moinul Haq stated that advocate Mohammad Safiur Rahman Mullah, accomplice Roman Mehdi, was pursuing the case of Mariam Begum. That is a mutation case. A circle of such and such. Accordingly, Mohammad Safiur Rahman took 2 lakhs rupees, such and such, such and such. Now it is, I am arrested on the basis of a statement by an co-accused. That is also, Lordship is aware.
No, during investigation that can be.
Yes, but the question is, Lordship, that on the basis of that statement I was arrested. If both the accused arrived as an accused person, then, Lordship, this is not, you cannot take the statement as an 161. And that is also a judgment of the Honorable Supreme Court. I will place before the Honorable Court for consideration of the 2019 judgment. So therefore, Lordship, considering this legal aspect, and this is the second FIR, I cannot be arrested, Lordship. Considering this aspect, Lordship, I am already in custody in and that, Lordship, unfortunately not addressed before this Honorable Court. Perhaps on the last occasion, if this issue has been addressed to this Honorable Court and canvassed before this Honorable Court, Honorable Court may consider and may take a view, Your Lordship, in other ways. That is my respectful submission.
Okay, Madam, you produce the case area of both the cases. We will examine the matter.
So, Lordship, on 2 bail application, 4707 and 4708, both are listed before this Honorable Court. And perhaps the other benches also constituted, Lordship, last day of the court.
No, provided the benches are constituted.
Yes, absolutely. Fixed it. If it's not reached, otherwise we'll defer. Perhaps, Your Lordship, all the benches of the Honorable Court may I enjoy the view festival, Your Lordship? May I enjoy?
But the thing is that we have to hear you. We have to examine the record. On that day, it may not be possible.
If it's placed before this Honorable Court, I have nothing to be worried because already a substantial part has been heard with this Honorable Court. And I also placed the second judgment, Your Lordship, Honorable Lordship kindly, it's a Lordship at the time earlier.
Heard Mr. B. Dotto, learned senior counsel assisted by Mr. So learned counsel for the accused, and also heard Miss A. Begum, learned additional PP for the state respondent. This second bail application under section 439 CRPC is prepared by accused Saifur Rahman Mullah, who has been languishing in jail Azut in connection with crime branch PS case number 9 of 2023. Under section 120B, 419, 420, 468, 471, 409 IPC for grant of bail. Further, having heard the submission of learned advocates of both sides, it is provided that the learned additional PP shall produce the case diary of crime branch PS case number 9 of 2023 and cyber PS case number 12 of 2023 before this court on Friday.
Gotcha. Grateful, Your Honor. Item 4.
এটাৰ কাৰণে মেনশ্যন কৰি 12খন
Lordship, it's a minor lordship. It will go to the juvenile board lordship.
Lordship, direction my lordship, I may be allowed to juvenile justice board here. Subject to verification of my birth certificate.
No, what direction is necessary? You can go and approach the juvenile justice board.
I am a minor lordship. Simple direction.
Yes. You withdraw this petition and go and file that.
In juvenile. Juvenile, कभी file पर.
There is lordship that if some direction, it will.
What direction?
To approach the juvenile justice.
No, no.
Subject to-
Mr. A.R. Karim, learned counsel for the petitioner submits that. An applicant submits that the applicant is a minor and he will approach the juvenile justice board. And as such, he want to withdraw this petition. Here is accordingly allowed this AB stands to dispose of on withdrawal. However, liberty will remain with the applicant to approach the juvenile justice board. No, to approach the appropriate forum by filing appropriate application.
Item 5.
Please, Your Lordship. It is a revision petition against an order framing of charge. Whereas the sole issue involved in this case is regarding applicability of section 17A of the PCA. So, my lord, in this case, at the time of charge, I am an IPS officer, my lord, accused in a disproportionate assets case. So I took a plea before the learned trial court that in my case, there was no substantial compliance of section 17A of the PCA. However, my lord, the learned trial court passed an order saying that in disproportionate assets case, my lord, prior approval under section 17A of the PCA Act is not necessary. So, my lord, the learned trial court has relied on a judgment of the
Where is the impugned order?
Impugned order, my lord, will find at page 177. And the relevant part, my lord, at page 181. May I read, madam?
No, not necessarily unfair. Reading of unfair. Page number 1.
Relevant part is at page 181.
No, no, the order
Order
starts
starts from 177, madam. Sorry, 175, madam. 175.
So operative portion of the order starts from?
My lord, the finding regarding 17A starts at 181, my lord.
Yes, what wrong with this order?
My lord, the only contention on this is regarding the applicability of section 17A, my lord. My lord, if my lord takes up section 17A of the PC Act, my lord.
What 17A
17A,
says?
17A of the PC Act, my lord. But
Yes,
as far as 17A is concerned, there is only one exception which has been given in the statute. The section 17A is not applicable in cases involving arrest of a person on the spot on the charge of accepting or attempting to accept any undue advantage for himself or for any other person. So, my lord, if any person is arrested on the spot, my lord, in trap cases, my lord, section 17A is not applicable. The proviso is very clear on this one exception, my lord. My lord, as
no,
far as
here charges have been framed against you under 13(2).
yes, my lord. So, madam, whether 17A is applicable in disproportionate assets case or not, because the judgment which has been relied on by the learned trial court, my lord, the Madras High Court judgment, as far as the Honorable Apex Court is concerned, or this Honorable Court is concerned, my lord, there is no judgment on this point. And the statute itself does not carve out any exception for disproportionate assets case. So, our prayer, my lord, is very limited, my lord. This Honorable Court will only examine as to whether section 17A is applicable in disproportionate assets case or not. If it is not applicable, my lord, then we'll go and face the trial, my lord. Otherwise, this issue will have to be decided because its finding has been given by the learned trial.
That which part of the order?
My lord,
What finding?
page 81, my lord, last paragraph, my lord. Last paragraph, my lord.
Yes.
In this case at hand, the allegation against the accused such and such is that he, being a public servant, acquired properties which are disproportionate to his known sources of income. So, as per the decision of the Honorable Madras High Court passed in such and such case, prior approval under 17A of the PC Act is not necessary. Our contention before this Honorable Court is that, my lord, there is no exception in that provision that in disproportionate assets case, prior approval is not required. And there is no judgment of the Honorable Apex Court or of this Honorable Court on this point, my lord. So, we are only praying for examination of this limited issue, whether 17A is required in disproportionate assets case.
Yes, Mr. Fukon?
My lord. Here, my lord, the kindly peruse the my lord, section 17A, my lord.
Hmm.
Here it clearly says, my lord,
Hmm.
inquiry or investigations of offence relatable to recommendations made or decisions taken by the public servant in discharge of official function or duties. No police officer shall conduct any inquiry or investigations into any offence alleged to have been committed by a public servant under this act, where the alleged offence is relatable to any recommendations made or decision taken by such public servant in discharge of his official function or duties. It is very much clear, man. And from the face of the records and the FIR and the search sheets, there, my lord, does not disclose anything regarding the 17A is applicable in this case. And moreover, my lord, the Law Commission's report and the intention of the legislatures in various judgments of the various high courts clearly say that, my lord, in disproportionate cases, my lord, the 17A is not. That's why, my lord, the last line, my lord.
No, the counsel for the petitioner submits that there is no judgment of the apex court on this point.
My lord, it's true, my lord, but the various high courts of, my lord, our state, my lord, they are very elaborately discussed regarding the 17A. It's applicable in disproportionate cases, not in which circumstances this 17A is applicable. But in our case, my lord, in the present case, it's, my lord, clearly shows, my lord, the face of the record, the 17A is not applicable. And there is no infirmity passed by the Ladi court.
If I may supplement, my lord, regarding the learned trial court's order, the learned trial court has not even considered as to whether this accumulation of disproportionate assets was regarding any decision taken or recommendations made. There's a blanket order which has been passed that 17A is not applicable in disproportionate assets case. Whether it is applicable in our case or not, the facts have not been discussed. My lord. Blanket order, it's not applicable. So we are only praying that minor will examine, since there is no judgment of the Honorable Apex Court. This Honorable Court will examine whether 17A is applicable in disproportionate assets case. On factual parts, my lord, we are not here only on this limited issue of law. My lord.
Heard Mr. S. Nova, the learned counsel for the petitioner, and also heard Mr. M. Kokon, learned wiki for the state respondent. In this petition under section 397/401, related section 482 of the Code of Criminal Procedure, the petitioner Rona Kale Hazarika has put to challenge the correctness or otherwise of the order dated 19/10/2023, passed by the learned Special Judge Assam in special case number 02 of 2022. It is to be noted here that by impugned order dated so the learned court below has framed charge against the petitioner under section 120B IPC, read with section 13(2) of the PC Act. Peruse the petition and the documents plus on record, and also peruse the impugned order dated 19/10/2023. Let notice be issued, returnable in 4 weeks. Mr. Fukon, you are representing respondent number 2 also.
My lord, they by name they have made a party, my lord.
His official duty, he has given this FIR, my lord, under his designation, my lord. So perhaps the learned PP can appear.
But sometimes we have faced difficulty, my lord, they have by name they have party, then it's very difficult for us.
Okay, let notice go at this. Step upon respondent number 2 be taken by registered post and also by usual process within a week from today. No formal notice is required to be issued to the respondent number 1 since Mr. M. Fukon, learned PP, appears and received notice. However, extra requisite copy of the petition will be furnished to him during the course of the day. Registrar shall call for the scanned copy of the record from the learned court below. List the matter after 4 weeks.
My lord, the issue of interim may be kept open, my lord, till after.
No, finally, we will resolve the matter.
Much obliged, my lord.
Item 6. I'm deeply obliged, my lord.
Please, your lordship.
Yes.
Lordship, revision petition, criminal revision is against the order of family court principals number 2, dated 12th October 2023, against an interim matter, FC criminal number 2 of 2023, a maintenance matter. There was a interim maintenance granted of rupees 10,000 per month. Your lordship, the order is on page number 12.
Order is at page number
12.
So you have been directed to pay maintenance to the respondent at the rate of rupees 10,000.
Yes, your lordship. But your
So you were agreed by that order.
yes, your lordship.
But the problem is that that order is interim order. Whether revision petition is maintainable against interim order.
Your lordship, we have come to this court to just maintain correct the order because the wife lives alone. Wife deserts her husband at her own will, and when she left her matrimonial home, she had given a
No, that's all right. But the legal question is whether the petition is maintainable against interim order.
Your lordship.
First, you have to satisfy the court that against interim order,
Yes, your
so petition is maintainable. Revision petition is maintainable. But some other judgments of this courts are that interim or and against interim order, no revision petition is maintainable.
should maybe granted some time to
Okay. What is your name?
Zed Hayat.
S.
Zed Hayat.
On the pair being made by Miss So-and-so, learned counsel for the petitioner, list the matter after vacation.
Yes.
What will suggest on that?
Holiday on 29th.
29th
Study number 8.
of this.
Non-appeals for the petitioner on call, list the matter after.
Item 9. Item 9.
Please, your lord.
Are you in item 9?
I'm item
No,
9.
7 and 8 lordship, they have taken time at 2 lordship, 7, 8 both.
Please, your lordship, this criminal petition has been filed for quashing of the affair dated 29/12/21 filed by the opposite party. Opposite party number 2 match. The affair is there as a page 16 manner. But before the proceed manner, the petitioner is an advocate man practicing at Nogam manner. For last 28
But
years,
the question is whether cases under section 376 IPC can be quashed.
my lord.
Can it be quashed?
Before, let me submit my, see, I am coming to it, my lord.
Yes.
Well, because before this affair was lost, the petitioner lost 2 affairs against this opposite party as the informant because he was staying as a tenant in his house, and then she started illegal activities in his house, and he asked her to vacate, and all this and areas of rents were also there. So prior to this affair, 2 affairs were lost because, and before, besides this allegations, my lord, she stated in the affair that she was also raped for last 5 years, but she did not make any complaint. And then this allegation regarding commission of rape on her child, that is after loss, this affair was lost after 8 days, my lord. So this honorable court also granted PRS bail to the petitioner on this grounds, my lord, which the order of this honorable court may kindly peruse, which is at
No, granting of bail and quashing of the FIR are 2 different
no, I am
aspects.
just on the grounds on which these are relevant factors, my lord, before 21, page 21, because this
Okay, and this is a let notice go.
that
And we'll call for the record. At what stage the case is pending?
My lord, still no case, the investigation.
Investigation. Okay, madam will produce the case diary.
Lordship.
Required.
Pardon me, sir.
I.A. Hazarika.
Hazarika, learned counsel for the petitioner. And also heard Miss A. Begum, learned additional PP for the state respondent. This application under section 482, read section 227 of the Constitution of India is prepared by Saiful Islam Chaudhuri for quashing the FIR of Nogao PS case number 3346 of 2021 under section 376/506 IPC, read with section 8 of the POCSO Act. It is to be noted here that above noted case has been registered on the basis of one FIR lost by one Srimati X. On 29/12/2021. Where is the petition and the documents placed on record? Let notice be issued to the respondent,
Number 2.
returnable in 4 weeks. Step upon respondent number 2 be taken by registered post and also by usual process within a week from today. No formal notice is required to be issued to the respondent number 1 since Ms. A. Begum learned additional PP appears and received notice. However, extra requisite copy of the petition be furnished to her during the course of the day. The learned additional PP shall produce the case diary before this court on next date.
19, Lordship.
19.
19 what?
No, in the meantime, notice has to be served upon respondent number 2. 4 weeks after 4 weeks.
February 1st. On 15 to 24.
15 to. Interim period of the petitioner will be considered after perusing the case diary on next date.
Much of.
Item 10.
My lord, may please. A 438 application, my lord. Vernacular FIR is on page 14, my lord, and the typed FIR is on page 12, my lord. May I read it, my lord?
Yes.
To the Superintendent of Police, Sonitpur, subject application complaint. Sir, with due regard, I would like to inform you that my son, Mohammad Mahir Ali, age 14 years, has been missing from the house since 17/2/2023. And in connection to that, I have lodged one FIR before the Singri police station. On the strength of the said FIR, an eyewitness, the police personnel had apprehended the below named accused person, and later on, after discussion and negotiation, they were released. But till date, the officer in charge of the said police station did not trace out my missing son. When I requested the police personnel to search for my son, they asked me to search for myself and to produce him. On the other hand, the accused person, namely Nosad Ali and his aides, always stare at me and my family members with evil eye and threaten to make us disappear. The Singri police station did not give any attention even after informing the above said facts to them. It has been almost 6 months since my son had gone missing, but still today I do not know whereabouts of my son.
Whether the victim boy was recovered?
No, my lord.
Not recovered.
Thereafter, my lord, the said FIR was forwarded to Thikwajuli PS, and Thikwajuli PS case number 143/23 was rated under section 365/34, my lord. My lord.
Okay, let the city come.
My lord, one more submission, my lord. All the petitioner, my lord, are the resident of the same locality, my lord. And my lord, the petitioner number 3 is the son of petitioner number 2. Moreover, the petition number 3, my lord, was a minor at the relevant point of time, my lord, on 17/2/23, when the son of the informant allegedly had gone missing, my lord. And the informant's son, my lord.
So you produce the relevant document, we will examine the matter.
My lord, regarding the petition number 3, my lord, we have annexed certificate copy of the admit card and provisional transfer certificate, my lord. There is
His birth certificate is there.
no, my lord, admit card and transfer. transfer certificate is there. Page 19 and 20, my lord.
We will examine the matter on next.
Interim may be granted, my lord.
No, interim.
Not recovered, lordship.
My lord, and one more important, my lord, the informant's son was not biological child, my lord, and he used to inflict all sorts of torture upon the said Mahir Ali, my lord. And there is likelihood that due to such torture, he have fled away, my lord. And
We'll
here,
see the case area. What is
Yes,
there?
after lordship.
Heard me, sir. Your good name?
A. Sharma.
A. Sharma,
A. Sharma.
learned counsel for the applicants. And also heard Madam A. Begum, learned additional PP for the state respondent. Apprehending arrest in connection with Dhokokana PS case number, Dhekizuli PS case number 143 of 2023 under section 365-34 IPC. This application under section 438 services prepared by three applicants, namely Nosad Ali, Moidan Ali, Amir Hamza, alias Amir Hamza, for grant of years bail. Having heard the submission of learned advocates of both sides, perusal of the case area is found to be necessary, and accordingly it is provided that the learned additional PP shall produce the case area before this court on
22-1.
22-1.
Item number 12.
May I please, your lordship? Lordship, FIR is at page, it starts from page 30. It's a very long FIR of 23 pages. Lordship, the fact of the case is that there are some FIR named accused persons who had a conspiracy and informed the informant that they are the top official. One of them is the top official of the government of Assam, and government of Assam is in need of certain supplies. So they issued fake work orders and executed fake memorandum of association with the informant in the name of Motok Autonomous Council. And the informant started supplying materials, that is mosquito nets, blankets, and school bags. And after supply of some payments were also made. When they verified, they found that the payments were made from the private account, not from the government, and ultimately the conspiracy came into light. And here the petitioner before your lordship, he is not the FIR named accused. He was also a victim of the same conspiracy, and when he went to the office of the Motok Autonomous Council, and they informed that the government supplies, their government supplies, and they need the big companies or the original manufacturer to give the supply. So he searched for these persons, and they came in contact, and thereafter they directly executed the MOU and others. And this petitioner, he was nowhere involved. Now during investigation, the informant has stated about him that he introduced them. So that is right.
Let the city come.
Lord, till then I may be
Offenses
protected
are-
because I can appear before the IO and I can state my position. What is my position? Actually, I am
Well,
also a victim. I am
well,
not named in
well-
the FIR.
We will finally protect you. If there is no material in the case,
Yes, Lord, that is there.
heard Mr. S.N. Tamale, learned counsel for the applicant, and also heard Ms. A. Begum, learned additional PP for the state respondent. Apprehending arrest in connection with CID PS case number 16 of 2023 under section 120B to 255, 256, 257, 259, 406, 417, 419, 420, 463, 465, 466, 468, 471, 70, 472, 474, 506 IPC. Reviewed section 7(1) and 7(2) of State Emblem of India, Prohibition of Improper Use Act 2005. This application under section 438 services prepared by applicant Rajiv Khan for grant of previous pay. It's to be noted here that above noted case has been registered on the basis of a FIR lost by. FIR is at page number 13.
Yes, Lordship. It starts from page number 13.
Who is the complainant?
Lordship, complainant here is the Messrs. Savarwal Trading India Private Limited. It's represented by its director. That is a page number second last page. That is. Lordship, page
On the
33
basis
is
of one FIR lost by one Kamal Sarewal. director and authorized representative of Several Trading India Private Limited on when it was filed,
It was logged on 10,
9th of
9th of
October
October
2023. Having heard the submission of learned advocates of both sides, perusal of the case area is found to be necessary, and accordingly it is provided that case area be called for fixing the matter on, Madam,
22 Lordship.
22. Interim pair of the petitioner will be considered after perusal of the case.
Item 13.
Please, your lordship. 438 bail application, my lord. FIR is at page number 15, my lord, and the vernacular one is at page number 19, my lord. May I read the FIR, my lord?
Game and Betting Act.
My lord, I am the owner of the Arakanats factory, my lord, and the accused number 1 and 2 are working in that factory.
No, case was registered under Game and Betting Act
My lord,
and also IPC 253.
my lord, and as well as my lord IPC, my lord. 252.
FIR is at page number.
Vernacular one is at page number 19, my lord. May I read the vernacular one, my lord?
Yes.
সন্মানপূৰ্বক বিনীত নিবেদন এই যে মই সঞ্চয় SI সোনু দেৱ বৰ্মন UBC 101 দিব্যজ্যোতি বৰা UBC 45 শাহজাহান আহমেদ HG আব্দুল খালেক HG আখিৰুল ইছলাম HG নুৰুল ইছলাম HG ৰাজীৱ পল উইথ হাফ সেকশন ASRF বেটেলিয়ান সহ উপৰোক্ত প্ৰসংগ মৰ্মে 18 চকী এলেকাত নিশা টহল কৰ্তব্য কৰি থকা অৱস্থাত এক গোপন সূত্ৰে জানিব পৰা যায় যে বুঢ়াকটা গাঁৱত শহীদুৰ ইছলামৰ সুপাৰী ফেক্টৰীত কিছুমান মানুহে অবৈধভাৱে জুৱা তাচপাত খেল খেলি আছে মতে সংবাদ পাই লগে লগে IC মহোদয়ক ফোন যোগে অৱগত কৰি সঞ্চয় ষ্টাফ সহ যোৱা ৰাতি 21/11/2023 তাৰিখে ৰাতি অনুমান 10:45 মান বজাত আমি বুঢ়াকটা গাঁৱত গৈ শহীদুৰ ইছলামৰ সুপাৰী ফেক্টৰীত গৈ নিম্নলিখিত আসামীগণে অবৈধভাৱে জুৱা তাচপাত খেল খেলি থকা দেখা পাই লোককেইজনক ধুত কৰাৰ বাবে চেষ্টা কৰাত আসামী কেইজনে আমাৰ কৰ্তব্যত বাধা প্ৰদান কৰে আৰু লাঠি লোহাৰ ৰড আদিলৈ আমাক প্ৰাণে মৰা ভাবুকি দিয়ে জুৱা তাচপাত খেল খেলি থকা আলী হুছেইন সন অফ লুৎফুৰ ৰহমান নামৰ লোকজনক হাতে লোটে কাৰায়ত্ব কৰি তেওঁৰ পজেশ্যনৰ পৰা 2 পেকেট প্লেয়িং কাৰ্ড এটা ৰেডমি মোবাইল হেণ্ডছেট আৰু কেছ ₹1500 টকা পাই সাক্ষীৰ সাক্ষাতত লগতে যোৱা SIP সোনুদেৱ বৰ্মনৰ সাক্ষাতত জব্দ নামা মতে জব্দ কৰি আটক কৰা লোকজনক লগতে
Okay.
my lord I am Shahidul Islam that the factory is mine my lord and accused number 1 and 2 are my employee who do the manual work in the factory from manufacturing raw areca nuts to a dry areca nuts my lord. So, and the arrested accused person has already been released on bail my lord. I could not get the bail order, but in the morning I got the information, my lord.
Heard Mr. Your good name.
MAI Hussain.
Learned counsel for the applicant and also heard Madam A. Begum, learned additional people for the state respondent. Oh, RJ Borua, yes. Yes, Borua?
My lord, he has been named in the FIR, Rosit, that's all.
I am admitted.
Owner of the, my lord.
I am the owner.
Godown, Rosit.
Maybe that 2 person may be playing, my lord, because in the night, my lord, for relaxation of mind, they may be played, my lord, but it's not used as a gambling adda, my lord. So interim may be given. I will appear to the IO, and the main arrested accused has already been released on bail.
Apprehending arrest in connection with Mankasar PS case number 428 of 2023 under section 12, 14, 15 of Assam Game and Betting Act related with section 353, 506 IPC. This application under section 438 services prepared by applicant Saifur Shahidur Islam alias Sahidur Islam for grant of various bail. The above noted case has been registered on the basis of an FIR lodged by ASI Jainal Abidin of Kalapani Outpost on 22/11/2023. The essence of allegation made in the FIR dated so and so is that acting on a tip of the informant along with other police staff conducted search in the godown. No, in the super factory of Saidur Islam and apprehended one person, namely Ali Hussein, while he was playing cards with one Ali Hussein. No, with one Zahidul Islam, Nazrul Islam, Sohidur Islam, Rakib Hussein, and Kosu Sheikh, and recovered 2 packets of playing card from the possession of Ali Hussein, and also recovered a sum of rupees 15,000 from his possession and seized the same in presence of witnesses. The learned counsel for the applicant submits that the applicant is the owner of the factory where the accused number 1 to 6 were playing cards, and then the accused number 1 has already been arrested here in this case and also granted bail by this court. And then the applicant is ready to cooperate with the investigating agency and therefore it is contented to allow the petition. Whereas Mr. Arjabora, learned additional PP, has opposed the petition on the ground that the FIR discloses the name of the applicant and he is also involved in the offense alleged in the FIR. And submits that at this instance only case hearing may be called for. Accordingly, para. Having heard the submission of learned advocates of both sides, perusal of the case hearing is found to be necessary, and accordingly it is provided that case hearing be called for, fixing the matter on Burwa.
24 or 5th.
24.
Right.
24. Para, considering the submission of learned advocates of both the parties and also considering the nature of accusation and the role played by the applicant, this court is inclined to extend interim protection to the applicant till receipt of the case hearing. And accordingly, it is provided that in the event of arrest of the applicant in connection with Mankasar PS case number so under section so he shall be released on interim period bail on his executing a bond of rupees 50,000 with 1 security of like amount to the satisfaction of the arresting authority. Above privilege is over subject to the following 3 conditions. Last condition is shall not leave the jurisdiction of CJM Mankasar, South Salmara Mankasar without prior permission.
Only one correction, my lord. The petitioner number 1 was granted bail by the trial court below, my lord. Session.
Session court.
File number 14.
Thank you, Your Lordship. 438 bail application, Your Lordship. Your Lordship, in this case, the petitioner before Your Lordship is the owner of the vehicle which was seized in the instant case, Your Lordship. Your Lordship, FIR is at page 15, Your Lordship. This is a long FIR, Your Lordship.
Let the city come.
Your Lordship, the owner of the vehicle, Your Lordship, after waiting.
Is the owner of the vehicle, Lordship. And 23 numbers of cattle recovered from the vehicle.
Your Lordship, all the relevant documents I have annexed.
So bosses stop here, so we will fix the short date on 18th.
19 Lordship.
19th. CD on 19th.
Item 15.
Please also, apprehending arrest in connection with the issuance of 41A notice, my lord, I approach this honorable court, my lord. My lord, case relates to the, my lord, that APSC, my lord, that case for job scam, my lord. That case has been, my lord, already investigated and trial has been going on, my lord. There are 47 accused persons facing the trial, my lord. Here, my lord, thereafter, my lord, by commission of inquiry has been constituted by the honorable justice retired B.K. Sharma, my lord. On that basis of inquiry report, my lord, I have been called by the police, my lord, to appear before the IO, my lord. Lordship may come to the, my lord, FIR, my lord, no one is name it there, my lord, but Lordship may come to the, my lord, page 20. This is a notice, my lord, for appearance. It is to be appeared on, my lord, on 12th, day after tomorrow, my lord. I am ready to appear, my lord. Only my apprehension is 3 persons already appeared on the basis of the, they have been arrested, my lord. That is my apprehension, my lord. And so cause notice has been issued, my lord. I have replied, my lord. And I appeared before the Justice Honorable B.K. Sharma's committee also, my lord. On the issuance of evidence, I replied also, my lord, dear my lord. Being a, my lord, I am presently posted at my lord, additional district commissioner of Boripur in Dhubri district, my lord. Now I am on training, my lord.
We'll sit as case diary.
My lord, day after tomorrow I have to appear, my lord. That's my appearance. I will appear, my lord. Some protection, my lord. Next that, my lord, if I am, my lord.
No,
any
without,
things found.
no, this is a sensitive case, no? Without going to the case diary.
No, my lord. In my
difficult
case, my
process
lord,
to-
it is subsequent, my lord. All who have been many, they are facing trial, my lord.
No, Mother, he can obtain time on 12 Lordship. Let the case diary be called for Lordship and element status report.
My lord, I will appear, my lord. Definitely on 12, I will appear, my lord. I don't want to miss the date, my lord. Only thing, my lord, the other 3 persons who appeared, my lord, met categorical statement, they have been arrested, my lord, after appearance. That is, my lord, I mean, my lord, apprehension,
So,
paragraph 13, my lord.
if that is your apprehension, you ask for time.
My lord,
That
another
showing
person,
that
my lord.
one anticipated bail application is pending
My
before
lord,
this court.
my lord, another person, my lord, who also approached the honorable court, my lord, he has been granted bail, my lord. Bail, my lord.
Maybe
You understand?
that was granted bail after perusing the case diary.
No, my lord. No, my lord. Lease on matter, my lord, not my lord, on interim, my lord. One Vikas Sharma, my lord.
No, this was granted taking note of the departmental proceeding initiated against the petitioner of that application. Whether any departmental proceeding has been initiated against you?
My lord.
Here.
No, my lord. Here, I'll have Lordship may come to the my lord. Annexure 5, my lord, that is submission of reply to the before the commission, my lord.
That is formation is different.
Then thereafter, my lord, I'm coming. Thereafter, my lord, annexure 6, my lord, page 20. This is a show cause notice, my lord. Talk to me, my lord. And I have replied on, my lord, to the show cause notice, responded, my lord, 30/12/2023, my lord.
No, this so cause notice was filed before the commission. Here, the petitioner was
My lord,
he was
first show cause
facing a
notice is regarding
departmental
commission,
proceeding.
second show cause notice
And
issued by
on
the
that ground,
departmental, my lord.
pardon?
From second show cause notice, my lord, annexure 7, my lord. Annexure 6, my lord, it issued by the my lord, department personnel, my lord. This is for doing a departmental proceeding, my lord. Department personnel, Assam Secretariat, my lord. These so cause notice I have responded on 30/12/2023, my lord. I have annexed my reply to the so cause notice also, my lord. First one is the before the commission.
No,
my
no,
lord.
here so cause notice was issued only to proceeding was not initiated. This is not the second show cause notice.
Now, this is a first show cause notice, my lord, for drawing of departmental proceeding, my lord.
But in this case, the petitioner has already been facing departmental proceeding.
Now, he also, my lord, like me, my lord, show cause notice was issued, he has responded, and now he is apprehending arrest, my lord.
Let us
In my case, my lord, the notice has been issued.
Let the matter be fixed on 12 lordship at 2 p.m. lordship, which produce the case diary and about status.
12.
12 on at 2 p.m. lordship.
My lord, 12, I have to appear. my
That he can take time lordship. There's no problem.
My lord,
Without the case diary lordship, I'm objecting.
Okay, 12 at 2 p.m. Case diary.
Item number 16.
Senior counsel, Mr. Peter is on leg in another board. Can it be taken after some time?
Who is the senior counsel?
Bhaskar Dutt.
Item number 50.
FIR list, yes, my lord. Earlier, a reason call for the report, my lord, whether the case is registered or not.
Okay. তো এই কি হয় এটা বিয়ে বাইট হয়ে যায় Yes, CD was called for.
No, my lord. Report was called for.
Oh, yes.
Well, after some time, lordship.
After some time.
Published.
50 and 51 lordship both after some time.
52.
Property duplication lordship. FIR is still lordship. Basically, lordship 135 of electricity act, merit lordship.
Yes.
With reference to the subject cited above, I have the honor to inform you that on 2012-2023, myself along with Sri Shahinur Islam, SMR and Riyazul Islam, Sahayak and other sub-divisional staff APDCL were conducting an anti-theft cum disconnection drive operation at Patakata village. During the operation, we have found an unauthorized electricity connection at the premises of Mirazul Haq, son of late Sophie Ul Haq at village Patakata, post office, South Salmara, PS South Salmara, district for Mankachar. He misbehaved and verbally abused our line staff, namely Riyazul Islam and other staff, while they were performing job duty. That is disconnection cum anti-theft drive on 2012-2020. Also, this was the allegation. And regarding lordship electricity, I have annexed one bill lordship. That is 13 lordship. Electricity bill lordship.
1-3.
Yes, that's 1-3. Here lordship, there is a pending bill admittedly 384 rupees. And subsequently, lordship, I have paid all the bills which I have brought on the record by way of affidavit lordship, additional affidavit lordship.
No, you have paid bill, but you use it unauthorizedly.
No, lordship, there is a consumer number also, lordship, in the
Where?
bill itself, lordship. In my additional affidavit, lordship.
No, you see the bill, this malpractice type,
Yes.
non-existing consumer theft of electricity.
Format, I think, lordship, but in the bill, lordship, where is consumer number reflected, lordship. Additional affidavit, lordship. Select A, lordship, page 19.
Page 19.
Yes, lordship. final assessment and payment also full one number lordship is there. And bill amount is so and so, and payment mode in cash, amount received so and so.
So when the occurrence took place,
Lordship occurrence took place on 21 lordship. So on 20 lordship, FR lost on 21.
so Mr. Borwa,
My lord,
if this is the receipt
my lord,
and it bears the consumer number
my lord.
and payment that is 12/22/12/23, 1 day after lodging of the FIR. So how can the connection become unauthorized?
That is why Lordship will examine the case diary, Lordship. Let him also appear before the IO and give his statement. Because it will reveal from the case diary whether he has paid or not.
Or Mr. A.Z. Ahmed, learned counsel for the applicant, and also our Mr. R.J. Borua, learned additional PP for the state respondent. Apprehending arrest in connection with Mankesar PS case number
Yes, lordship. 360.
360 of 2023 under section 294, 353, 379, 506 IPC, read section 135 Electricity Act. Its application under section 438 services referred by applicant Mirazul. Mirazul Haq for grant of pre-arrest bail. The above noted case has been registered on the basis of one FIR lost by one. Sheikh Abdullah on 21/12/2023. The essence of allegation made in the FIR dated so and so is that the applicant unauthorizedly used electricity connection at his premises and he misbehaved with the informant and other stuff. While they have conducted a drive to disconnect the unauthorized connection. Mr. Ahmed, learned counsel for the applicant, referring to Annexure 1 at page number 19 of the petition submits that the petitioner submits that the applicant had made payment of a sum of rupees 48,384 rupees and in the said receipt, consumer number, receipt number, invoice number, and name of the consumer is also mentioned. And as such, Mr. Ahmed submits that the connection in the premises of the applicant is not unauthorized and he is no way involved with the offense alleged and therefore it is contended to allow the petition. On the other hand, Mr. R.J. Borua, learned additional PP, submits that perusal of the case there is necessary in order to verify the contention so made by the applicant. Having heard the submission of learned advocates of both sides, perusal of the case area is found to be necessary and accordingly it is provided that the arrest shall call for the Mr. Borua, learned additional PP shall furnish the case area before this court on when Borua?
29 also.
29. Considering the submission of learned advocates of both sides and also considering the document, especially Annexure 1 plus before this court, which indicates the consumer number and the name of the applicant and the bill amount. This court is inclined to extend interim protection to the applicant. No. This court is of the considered opinion that the applicant may not be unauthorized connection. The unauthorized user of the electricity as alleged in the FIR. And therefore, this court is inclined to extend interim protection to him till receipt of the KZB. Accordingly, it is provided that in the event of arrest of the applicant in connection with Mankasar case number so and so under section so and so, he shall be released on interim period pay.
And he produce the necessary documents before the.
On his executing a bond of rupees 50,000 with one share return like amount to the satisfaction of the arresting authority. The above privilege is however subject to the following three conditions. Last condition is shall not leave the jurisdiction of CJM, South Salmora, Mankasar without prior permission. First condition, he shall appear before the IO with all relevant documents.
53.
My lord, the FIR was lost in the year 2015, my lord. Saying that, my lord, some numbers of cough syrup bottles have been recovered from an auto. I am not the owner of the auto. I am not the owner of the garage. And my lord, the owner of the auto was granted anticipatory bail. Owner of the garage also granted anticipatory bail. My connection, my lord, the garage which was situated, the land belongs to me, my. In my land, the garage was situated. Thereafter, my lord, police investigated and filed final report. On 39/2019. Thereafter, my lord, the prosecution submitted to take cognizance, my lord, without hearing the informant, without hearing the investigating authority, that directly taking the cognizance of this case. Meanwhile, my lord, the main accused, my lord, Bashir Ahmed and Musaddar Ali have been died. And I am the owner of that land, my lord, and the cognizance is taken against 3 persons, where 2 persons have been died. And I am the sole person who is remaining with the owner of the land where the garage is situated. And nothing, my lord, no connection is there. And now, my lord, the summon issued to me. Under
Yes, Gaurav?
Someone issued to him notice. The scan copy be called for.
My lord, may I read, my lord? Page number 22, my lord. Page number 21. This is the cognizance is taken, page number 21.
No,
And
here, the section under which the case is
22C,
registered is 21C.
22C/29. Cognizance is taken, my lord, under this section. Page 21, my
Let
lord.
the record come.
My lord,
Justice shall call for the scan copy of the record of session case number. Session
5/2015.
special NDPS case number
5/2015.
from the Court of Learned Session Judge
Karimganj.
fixing the matter of
29.
29.
And my lord, till then, my lord, in the prima facie, my lord, I am innocent, my lord. Nothing against me. Nothing against me, my lord.
Commercial quantity.
My lord, on the prima facie case, my
We
lord.
will finally protect you. Let the record come. If there is no material, we will protect you.
Item number 17 for admission.
May it please your lordship. Well, there is a criminal appeal. I have been convicted under section 354 of the IPC and section 12 of the POCSO Act. The impugned judgment is at page 56, and I have been sentenced to undergo for 2 years, and I am on previous bail. The operative part, your lordship will find at page 69. Para 29, 69 para 29. Para 29. Having considering the leniency, I am Well, I happen to be a headmaster of a school, my lord. The allegation is that I called the victim to my office and asked her to plant a case for my chick.
Yes, heard Mr. Jay Bora, learned counsel for the applicant, no, appellant, and also heard Mr. Arjay Bora, learned additional for the state respondent. In this appeal, under section 374, within bracket 2 of the Code of Criminal Procedure, the appellant, namely Suresh Sharma alias Suresh Chandra Dev Sharma, has put to challenge the correctness or otherwise of the judgment and order dated 15/12/2023 passed by the learned session Judge Karanganj in special session case number 20 of 2019. Full stop. It is to be noted here that by the impugn order dated so and so, the learned court below has convicted the appellant under section 354A IPC read with section 12 of the POCSO Act and sentence him to suffer rigorous imprisonment for a period of 2 years and also to pay a fine of rupees 10,000 with default stipulation, under section 12 of the POCSO Act. Peruse the memo of appeal and the grounds mentioned therein, and also peruse the impugned judgment and order dated 15/12/2023. Parasins admit. Call for the record from the learned court below. Issue notice to the respondent number 2 by registered post and also usual process within a week from today. No formal notice is required to be issued to the respondent number 1 since Mr. Arjay Borua, learned additional PP, has appeared and accepted notice on behalf of the respondent number 1. However, extra requisite copy of the petition will be furnished for him during the course of the day. The learned counsel for the appellant submits that since the appellant was convicted to suffer rigorous imprisonment for 2 years only, he was allowed to remain on previous bail and by the learned court below, and he also pays for allowing the appellant to remain on previous bail till disposal of this appeal. There is accordingly allowed. The appellant is allowed to remain on previous bail. In terms of the order dated today, passed in a criminal appeal number so and so, the IA. Is there any IA?
Yes, my lord.
The IA number
15 for
15,
suspension of the sentence.
2024 stands closed.
And my lord, the sentence may be suspended. The sentence may be.
You have been allowed to remain in
Yes.
previous bail.
Yes. All right.
Item 18 for bail hearing.
Wait, please, your lordship. This is 439 bail application, my lord. Your lordship, on 19/10/2023, my lord. This honorable court had granted, my lord, bail, my lord, on condition that the petitioner shall render voluntary service, my lord. And my lord,
Case lordship, this is the wrong case, there, lordship.
but my lord, petitioner has rendered service, my lord. This is the certificate.
City to Ahana.
Mr. Arjay Borua, learned additional PP, submits that he has not received the case diary and press for granting him some more time. There is allowed. The interim order passed earlier shall continue till then.
Obligement.
My lord, let it be on my lord 29 or so.
29.
29/1.
Obligement.
Item number 19.
Your Honor, my lord, Kannadi Kasir could not appear today due to personal health issue.
Pardon?
Due to some personal health issue, Kannadi Kasir could not appear today. Kindly fix the matter on Friday.
When?
Friday, my lord,
Friday.
several cases already been fixed, lordship.
Friday. Friday may not be possible. 18th, what is your name?
Dikshika Prashad, D Prashad.
So and so learned counsel for the accused. Press for listing the matter on 18th. Pair allowed.
Item 20.
Yeah, please, Your Lordship. My lord, the petitioner is behind the mark for 84 days, Lordship.
Pardon?
84 days.
84 days.
My lord, allegation under section 376, Lordship.
Search it submitted?
Search is not submitted, Lordship. Otherwise, Lordship, material collected, Lordship.
Huh?
All the materials collected against me.
86.
Allegations appears to
So
be very
here, mandatory period is 90 days.
90 days, Lordship. Today is about
So 4 days remains.
4 days remain.
Whether you will be able to submit search it or not, that is the question.
We will have to send back the case there.
Pardon?
We have to send back the case there.
Case ID is available here.
Yes, my lord.
Is there any material?
Yes, my
against?
lord. Already material collected. 164 statement, medical report, everything.
Can I
Yes,
see
also.
164
My
statement?
lord.
Although the serious allegation lawsuit has been brought against the Lordship, the petitioner is victimized in this case, Lordship, as circumstances.
Pardon?
By circumstances, Lordship, in fact, the incident was taken place with other person, Lordship, but a marriage proposal was given to me. That was disagreed by the petitioner, Lordship. That's why, Lordship, the petitioner has been implicated in this.
But whether notice was served upon respondent?
Yes, Lordship, notice.
When?
Lordship, we have taken a step, and that is to be, Lordship, served through the Lordship officer in charge of the police station.
Served or not?
But office note indicates that you have not taken any step.
Before, Lordship,
No notice for service of notice. No step for service of notice upon respondent number 2 has been taken.
but that was taken through the office of the TP, Lordship, not through the registry.
No, no, no. Official people, we only my lord forward the pilot notice, Lordship, to the officer in such concern. We cannot serve. We must have forwarded to the officer in charge of the concerned police station.
Who is PS?
And that's Mankasa.
Mankasar. Barua, can you confirm from the officer in charge of Mankasar whether notice was served upon the respondent number 2
At 2 p.m. then.
Okay. Okay, case daily.
21.
May I pick my lordship, searched case, my lord. This scan copy was called for.
My lord, in this case, Lordship, notice was served to the my lord, victim, Lordship. Now, Lordship, the victim woman and the my lord, informant, they have came before the honorable court, Lordship, and they have objection in my lord regarding granting bail of the accused person, Lordship. If Lordship permitted, then I may be allowed to, my lord, call them inside the court.
My lord, I am behind the bar more than 4 months, 29 days, my lord. Already 2 witnesses examined, my lord. Victim and informant already examined, my lord. Remain only 2 witnesses, my lord. That are the hearsay witness, my lord. And other 3 witness is a seizure witness, my lord. Main witness, victim and informant already examined.
Victim examiners PW2, Lordship.
Yes. One also informant.
So how many witnesses have been cited in the search?
Total 9, my lord. Out of 9, 2 government witness, my lord, along with IO and doctor, my lord, and 3 seizure and 2 hearsay and 2 men. That 2 already examined. Informant and victim, my lord.
So under what provision the search was framed?
Search was framed purpose to, my lord.
And what is this section 376(3)?
376(3), Rep, my lord, and POXO is there, my lord, and 307 also.
He was below lordship.
Below 13 years, for 15 years, my lord. He is a minor, my lord.
So punishment is shall not be less than 20 years.
Lordship, medical report is totally negative, my lord. There is a medical report, my lord, medical report is
Maybe,
totally
but
negative.
at this it says while dealing with bail application, this court cannot appreciate the evidence.
Two evidence already I have taken, my lord. That is over. On the other hand, the fact is, my lord, there is a land dispute, my lord. That things is admitted by the informant in her cross examination.
Maybe, but merely because there is a land dispute, the court cannot presume that the allegation level against the petitioner is false.
Can you see the medical report, my lord? The medical report totally negative, my lord. On the other hand, more than 4 months, 29 days, he is behind the bar, my lord. He is a mental patient also. He is suffering mental disease, my lord. Go on bail, my lord. I will face the trial. Already I am facing the trial, my lord. And two witnesses there. There is a hearsay witness, my lord.
Yes, Mr. Bora.
My lord, Lordship, Perozzi, my lord, evidence of the PW2, Lordship. She has given, my lord, before the honorable court, trial court, that my lord, judgment read. And secondly, the medical evidence, Lordship. Medical evidence also very important.
Whether the doctor was examined?
Not yet, Lordship. Because after the 9 witnesses, only 2 witnesses have been examined.
Medical report, page 40, my lord.
40 of?
40 of my petition. That.
So this number 3 points.
Lordship.
Point in the medical report.
Lordship. All injuries present over the genital are suggestive of the penetration or the insertion or the manipulation committed over the period of the times, my lord. That is not in the present, my lord.
Pardon?
Not in the present time found, my lord. That was old injury was there, my lord, in the period time, my lord. That may be other cause may be happen.
The informant, my lord, they have received notice, Lordship. Yes. And they opposed the, my lord, prayer for bail, my lord.
Already the lower court also, my lord, 2 times my bail prayer is rejected, my lord, on the ground. That rejection order, my lord, base number 56, my lord. My lord. Last 57 is correct. Last is 57, my lord. I am not inclined to allow the bail petition is released on the accused might cause their threat and danger to the life of the victim and other material witness. Hence, the bail petition stand rejected and disposed of accordingly. And earlier occasion also, same ground, my bail petition was rejected. That also.
Yes, is it not a justified ground for rejection of your bail application?
Already in the victims and informants witness already examined, my lord. So
no, the other witnesses are there.
Only 2 witnesses are there. They too are the hearsay witness, my lord.
Maybe, but going to the evidence of PW2, whether a case for granting bail is made out against you.
My lord, I will face the trial, my lord. Kindly allow me the length of the detention, my lord. More than 5, near about 5 months, my lord. 4 months, that's 29 days, my lord. I'm behind the bar, my lord.
Heard Mr. A.R. Mehdi, learned counsel for the accused, and also heard Mr. Arjaboro, learned additional PP for the state respondent. This application under section 439 services prepared by accused Nasrul Haq, who has been languishing in jail in connection with Rangya PS case number 456 of 2023. Under section 450, 376 within bracket 3 IPC, read with section 4 of the POCSO Act for grant of bail. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Rahena Begum on on 11/8/2023. The essence of allegation made in the FIR dated so and so is that on 11/8/2023 at about 1 p.m. when Nasrul Haq entered into her house while and committed rape upon her minor daughter, Srimati X. And when her husband arrived at her house, then the accused tried to commit murder of his daughter by pressing her mouth with a pillow. And then the accused fled away from the scene of occurrence. The learned counsel for the accused submits that the accused is languishing in jail for last 5 months, and that the learned court below has also examined the informant and the victim. Out of the how many witnesses have been cited?
My lord, total 9, my lord.
Out of 9 witnesses cited in the search sheet, and that there is a land dispute between the accused and the informant, and that the learned court below has rejected the bail application of the accused twice on the ground that if the accused be released on bail, he might cause threat and danger to life of the victim and other material witnesses, and that the accused is ready to cooperate with the investigation. The accused will appear before the learned court below on each and every date, and therefore it is contented to allow the petition. Whereas Mr. R.J. Borua, learned additional PP, submits that the evidence of the victim is supported by the medical report, and the offenses are serious in nature, and only 2 witnesses have been examined by the prosecution side till date, and therefore Mr. Borua has opposed the petition. Para, having heard the submission of learned advocates of both sides, I have gone through the petition and the documents placed on record, and also perused the scanned copy of the record received from the learned court below. It appears that the learned court below has framed charge against the accused under section
450, 376, 307. And we read section 4, my lord.
under section 450, 376, 3 and 307 IPC related section 4 of the POCSO Act. Further, it appears that as many as 9 witnesses have been cited in the search sheet, and out of the 9 witnesses, only 2 witnesses, the informant and the victim, have been examined here in this case. Having gone through the evidence of the witnesses examined by the learned court below, and also having considered the materials placed on record, and also the nature and gravity of the offense, this court is of the view that this is not a fit case where the privilege of bail can be granted to the accused at this stage, and accordingly the petition is then dismissed. However, the learned court below is directed to expedite the trial, and if necessary, to take recourse of section 3091 CRPC and to complete the same within earliest possible time without being influenced by any of the observation made by this court herein above. In terms of above this, DA stands disposal. Can you confirm to the concerned officer in charge of concerned PS? Second half? I'm sorry. So at 2 PM then let him obtain instructions.
Item 23. Lordship, FIR, Lordship. Base 15, Lordship. And thereafter, Lordship, search sheet was laid on 39/2023. And as on today, the included behind the bar 160 days, Lordship. So, since search sheet has been laid, Lordship, at this stage, we may not delve into the merit of the case, Lordship. Because your Lordship has laid down that after laying down of the search sheet, kindly have a look, Lordship, para 8/6 of the bail application. The law has been laid down by your Lordship, the concept and philosophy of bail.
What law was laid down by this court?
By this court also.
Yes, what law?
In parallel, when it was held by this honorable court that the concept and philosophy of bail was discussed by honorable Supreme Court in several judgments. A distillation of plethora of the precedents would reveal that conceptually bail continues to be understood as a right for assertion of freedom against the state imposing restraints. Dictionary meaning denotes it as a security for appearance of a prisoner for his release. It is a conditional liberty. It must be regarded as a mechanism whereby the state devolves upon the community the function of securing the presence of the prisoner, and at the same time involves participation of the community in administration of justice. Lordship, kindly come to page 44, Lordship, an additional affidavit has been filed, Lordship. In para 5 of the additional affidavit,
Page number?
page number 44, Lordship. Para 5. Lordship,
No, here no page number 44 is there.
what additional affidavit, Lordship? An additional affidavit has been filed, Lordship. Official release, Lordship. Each available has
Page number?
page number 44.
It was 40. Of the service. No 44 page number is there.
Lordship.
Additional
affidavit, Lordship.
affidavit.
Black B part, Lordship.
Affidavit filed, received by registered services, additional affidavit B. Yes.
Lordship, got it.
Yes.
Very Lordship.
Yes.
The deponent begs to state that in the bail application in para 8, it has been averred that the concept and philosophy of granting bail after laying down of the search sheet has been articulated by a coordinate bench of this honorable court in bail application number so and so. At this stage, it would be opposite to state and submit herein that the Honorable Apex Supreme Court of India in the case of so and so
held in paragraph number 15 that just as the disobedience to a specific order of the court undermines the authority and dignity of the court in a particular case, similarly, the deliberate and malified conduct of not following the law laid down in the previous decision undermines the constitutional authority in respect of a high court. This was the
How this observation will help you?
Lordship, because I am a local resident of that area, Lordship, I will appear regularly. And apart from this, Lordship,
And how this observation is relevant in your case?
this is the ratio, Lordship, because
What ratio?
this honorable court on earlier occasion laid down the conceptual philosophy of bail. So, Lordship, apart from that, Lordship, kindly come to para 9, Lordship, of the main bail application. Another constitutional court, that is Honorable Madras High Court, in a case, Lordship, articulated the object and philosophy in enacting of the POCSO Act by the legislation, Lordship. Dear Lordship, the Honorable Madras High Court has held that
No, here search sheet is submitted.
search is submitted.
And whether search has been framed against you?
No, Lordship, that my another leg of argument, Lordship. The cognizance was taken on, Lordship, 16/11, and subsequently the matter was posted on 29/11 for copy and physical production of the accused, Lordship. On that day, no copy were served. The accused were not physically produced from the jail hazard, and subsequently the matter was posted on 13/12. On that day also copy were not served. Neither the accused were also not produced from the jail hazard, and subsequently the matter was posted on 27/12, Lordship. On that day also copy were not served. Subsequently posted on 8/1. On that day also copy were not served. And as such, Lordship, there is no immediate chance of conclusion of the trial, Lordship. And such delay has been caused on the part of the prosecution, Lordship. And in a recent
How?
Lordship, because the copy were not produced, Lordship, last 4
Who
days,
will furnish the copy? Prosecution side or court?
I have obtained a certified copy of last 2 orders, Lordship, because though LCR will call. But
No,
this-
LCR was called for and
Call
it
for,
is
okay.
available here.
But these 2 orders are not available in LCR because on earlier date LCR was received.
How the prosecution is responsible?
So, Lordship, in the case, Lordship Manish Sisudia, the Honorable Apex Court has held that the constitutional mandate is higher law and it is basic right of person charged of an offense and not convicted that he be ensured and given a spirit trial. When trial is not proceeding for a reasons not attributable to the accused, court, unless there are good reasons, may well be guided to exercise power to grant bail, Lordship. So, Lordship, I am a local resident, Lordship. Already 160 days I am behind the bar, Lordship. And apart from that, Lordship, some medical documents of the element of the murder has been brought on record by of the additional affidavit, Lordship. She needs immediate intervention on the part of the gastroenterologist, Lordship.
What illegal intervention?
Lordship, kindly come to the additional affidavit, Lordship. Additional affidavit, Lordship, page 42. Page 42.
Yes.
As your Lordship has it.
Yes.
Para 3, Lordship, the reported back to state and submit that she has been suffering from severe stomach pain. Since long and on being unable to bear such pain, she visited the Putimari mini CHC on so and she was advised by the attending doctor to undergo USG whole abdomen. Accordingly, ultrasonography was done on so at Ayushman Diagnostic Center at Bahadasariali, wherein it was found that the deponent has been suffering from hyperemic facial wall and left hypochondrial bowel as described, inflammatory, infective pathology. Accordingly, after perusal of such report, Lordship, the attending doctor advised her to visit the gastroenterology department, Lordship. And in the locality of the petitioner, Lordship, there is no gastroenterologist, Lordship. And she needs to visit the tertiary care hospital like GMCS, Lordship. And the mother of the petitioner is dependent upon the son, that is the accused, who is behind the bar, Lordship. And I have also annexed the USG report, Lordship, as well as the prescription, doctor prescription. Lordship, will find at page 48 the prescription, that is the next 4. And Lordship will find the USC report at page 50 and except 5. I will appear regularly during the course of the trial, Lordship. I am a local resident, Lordship. Any condition may be imposed, Lordship.
That's all right, but what is the guarantee that he will not try to influence the witnesses?
I sincerely undertake before your Lordship not to cause any kind of influence, Lordship. That
Yes, Mr. Barua?
My lord, it is true, my lord, premature, Lordship, because purpose has not been observed, Lordship. Search is yet to frame, Lordship, and victim is yet to examine, Lordship. Let the victim be examined, after that, Lordship, is very clear.
in my respectful submission, there is no immediate search, Lordship.
So, yeah, how can you say, Lordship, there is no immediate search?
Say,
The trial court has fixed date, Lordship, on, my lord, 13/12, then 27/12, my lord, then 18/8/1, Lordship. The trial court has fixed the date, my lord, it is not the trial court has fixed a long date, Lordship, after 2 months, 3 months, Lordship.
Lordship, in that case, Lordship, in para 10, Lordship, of the main bail application, I have averred that the Honorable Apex Court, while protecting the accused of a POCSO case, Lordship, directed not to influence the victim, Lordship. I have specifically averred and submitted in the para 10, Lordship, SRP criminal number so and so.
No, let the evidence of the victim be recorded, thereafter we'll consider your prayer.
So, Lordship, since 22/1 is fixed for copy, Lordship, let the copy be collected, Lordship, till matter may be postponed thereafter, Lordship.
As agreed by learned advocates of both sides, list the matter. Kabir, last part.
30.
30. In the meantime, Resty shall call for up to date status report from the learned court below.
Much.
24.
Application. 439 application, Lordship. Petitioner was shown arrested on 7/9/2022, Lordship. Today is about 490 days, 1 year, 4 months period, Lordship. FL is at page 22, Lordship.
Case that he was called for?
LCA call for, Lordship.
Succeeded case.
Succeeded case, Lordship, can copy call for Lordship. The Lordship already granted bail to the other co-accused who was forwarded on the same day, Lordship. Lordship order is at page number 100, Lordship. In my petition.
Page number?
Page number 100, Lordship. On the same date, this petitioner also forwarded, Lordship, in the same case.
Oh, what is the latest stage?
Still, Lordship, one witness examined before the trial court, Lordship. It is yet to be examined 56 numbers, 56 numbers of witness.
Yes, Mr.
Lordship, I've concluded LCL Lordship. Here in this LCL Lordship, I have found Lordship that the statement of this present petitioner, his statement is not available, Lordship. 161 statement is not available, Lordship. And only 3-4 statements are available. 4, 5, 6% statements are available. I think all the statements has not come. And this LCR is not called in this case. It was called earlier in other cases, Lordship, which has already been disposed of, Lordship. So it is it has come as a dispose of along with the dispose of matter, Lordship.
It
I
is,
think lordship,
it is each submission made by the learned PP lordship to connect this matter with this lordship. Then lordship, lordship gone through older record. After that, this was passed. Lordship, if anything is there, that is page number 71, in the charge sheet, the against this person is mentioned. Same thing, same allegation is made in the charge sheet, lordship, against those persons who got the bail from this honorable court, lordship.
Yes, local, you go through the search sheet. And the materials
that
collected against
search
the
sheet,
present accused.
Page number 70.
lordship, it is page 71, lordship.
You inform me later on. Second half.
25.
In the meantime, you go through the record.
Please, your lordship. My lord, 55 days I'm in custody, lordship.
Pardon?
I'm in custody since 55 days as of today.
45 days.
55.
55 days.
Allegation under section 21B, lordship.
21B.
B. CD was called for on the
Borua, case they received?
Well, the case are not received, lordship. So we can, my lord, fix it on, my lord, day after tomorrow, lordship, at least.
From which PS? Bongo.
Yes. Already 55 days, lordship, I kindly consider.
Can you confirm that search sheet has not been filed in the meantime?
Then at 2 PM, lordship.
Okay, 2 PM.
All right.
26. Pottery and application, lordship, FIR is on page 14, lordship. 14 numbers of cables are recovered, lordship, and as of today, it is 32 days behind last.
Yes, Borua, you received
My
the
lord, we
case
have
diary?
received the case diary, lordship, my lord, cattle transported without any document, lordship. That is why, my lord, while, my lord, at the time of my lord, interception, lordship, they could not produce any valid documents. That is why, my lord, they were arrested, lordship. Driver and handicap.
What is the stage of investigation?
The stage of investigation, my lord, they were asked to produce the, my lord, document, lordship, but they could not. Then, lordship, the cow which was, my lord, recovered from the vehicle, it was given Zimma to the, my lord, one Gosala. Further investigation is pending, lordship. Where from they have gone and required to, my lord.
Whether witnesses have been examined?
Eight
Yet?
witnesses examined.
So for 1 month they are behind the bar. Whether further custodial interrogation is detention is required?
That I leave it to lordship, my lord.
32 days, lordship, and already the cattle has been recovered, lordship, and the required documents will be provided by the vehicle owner, lordship.
Heard, Mr. Learned counsel for the accused and also heard Mr. RJ Borua, learned additional PP for the state respondent. This application under section 439 services prepared by 2 accused, namely Ariful Islam and Dilwar Hussain, who are languishing in jail in connection with Losisto PS case number 774 of 2023 under section 379 IPC, read section 11(1)B of Prevention of Cruelty to Animal Act, read section 13(1) of Assam Cattle Preservation Act. It is to be noted here that a noted case has been registered on the basis of one FIR lodged by one Sinmoy Borua of Zorabad Police Outpost on 10/12/2023. The essence of allegation made in the FIR dated so and so against the applicant is that on that day at about 9 AM, the informant. No, on that day at about 9 a.m. they have carried 14 numbers of cattle in one Bolero pickup vehicle bearing registration number AS02DC 4211. Without relevant documents. The learned counsel for the accused submits that the accused were arrested on 10/12/2023 and since then they are languishing in jail Azut for last 1 month. And that they are ready to cooperate with the investigating agency and therefore it is contended to allow the petition. On the other hand, Mr. R.J. Borla, learned additional PP has produced the case before this court and submits that the IO has collected sufficient incriminating materials against the accused persons who have carried 14 numbers of cattle in the vehicle without any documents. However, to a appointed query of this court, Mr. Borla submits that the investigation has been progressed sufficiently. Having heard the submission of learned advocates of both sides, I have gone through the petition and the documents placed on record and also perused the case area with the assistance of Mr. Borla, learned additional PP. Indisputably, both the accused were arrested on 10/12/2023 and since then they are languishing in jail Azut. It also appears, the case area indicates that material part of the investigation is almost over. And in the interest of investigation, further custodial detention of the accused persons may not be required in the interest of investigation. And accordingly, this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 or one security like amount to the satisfaction of the arresting authority, the accused persons being on to the satisfaction of the learned chief judicial magistrate Kamarpan, the accused persons be and less than bail. In terms of above this, be a sense disposal.
27.
Like.
At 439 application, I was arrested on 11/12/23, already 30 days behind the bar, my lord. An allegation is under section 120B, 406 and 420, my lord. FIR at page number 7. There is no allegation against me, my lord, in the FIR. In fact, all the allegation is against my wife. May I read the FIR? Page 7.
Borla,
My lord.
Sharma, you received
My
the
lord,
case
received
area?
the case diary, my lord.
So after perusing the FIR,
My lord.
it appears that allegations are basically against Mrs. Bijoya Dotto Soikia.
My lord, wife.
Yeah, wife.
Wife,
What
my
is what are the materials against
My
the
lord,
present
here is
accused?
the my lord, he has a plot of land, my lord. From the case, it reveals that he has sold it to several persons, my lord. That plot of land.
No,
sold
no.
to
Who
several-
sold the plot of land to this lady?
My lord, that
The wife who entered into agreement.
my lord. In one case, my lord, he himself. In the present case, not my lord. In the another case, my
No,
lord.
no. I mean, we are not concerned with
My-
other cases. We
My
are
lord.
concerned with the present case.
My lord, as per statement of his wife, my lord. Wife, statement of the wife, my lord. He said that as per direction, my lord, he has done this, my lord. She has done.
She has done.
My lord. And from his statement, my lord. Fortunately, his statement, my lord.
My lord, my wife has been granted, my lord, anticipatory bail.
But
interim bail, my lord.
he the owner, absolute owner of the land, my lord. Husband, my lord. Showing that land, my lord, he has taken money from several persons.
Though the deed was executed in the name of the wife, you are the person behind it.
My lord. Behind.
My lord, in the present case, my lord, in the present case, no payment has been made to me, my lord. Now, see, my wife has been granted anticipatory bail, my lord, by the.
No, here in the FIR itself, there is a indication of payment
Yes,
by SEC.
My lord.
By check to my wife, my lord, not to me, my lord. I have in this case, my lord, I have done nothing. my lord.
That is the modus operandi
My lord,
adopted by you.
My wife has been granted anticipatory bail, my lord. Kindly come to page
But
number
from
3
the
of the-
statement, my lord, from the accused person, my lord, he sold to several person and taken advance. Lastly, he has
only one case is pending.
he has
case
made
my lord.
one agreement, my lord.
Let him remain inside
Kindly,
for
already 30 days behind the bar, my lord.
for some time.
My lord, already 30 days behind the bar.
Otherwise, if we enlarge him on bail, he
My lord,
will
again he will
sell
sold.
the matter, sell the land to another person.
My lord.
My lord, in connection with this case, my lord, a written agreement is there, my lord. There is civil remedy is also available.
No,
to them.
no, as because there is civil remedy, it cannot be said that criminal case cannot lie.
My lord, my earlier cases are.
Heard Mr. A. Saleh, learned counsel for the accused, and also heard Mr. Arjay Burwa, learned additional, no, Mr. B. Sharma, learned additional PT for the state respondent. This application under section 439 services deferred by accused Sadananda Soikia, who has been languishing in jail in connection with Sunmari PS case number 445 of 2023 under section 123 406 420 IPC. Since 11/12/2023, for grant of bail. The above noted case has been registered on the basis of one FIR lodged by one Bijoya, no,
No, my lord.
lost by one Ruby
My
Chakraborty
lord. Ruby
and Pramodhesh Chakraborty on 2/12/2023. The essence of allegation made in the FIR dated so and so is that the informant have entered into an agreement with the wife of the present accused for selling a plot of land measuring 10 leases covering Doug number 613 of KP Patra number 1094 under Dispur Revenue Circle on 7/3/2021 and a sum of rupees 8,50,000 have been paid for advance. And thereafter on repeated requests, she has failed to initiate the sale process or to refund the money. And later on, it has come into light that Mrs. Bijoya Dotto Soikia is not the owner or the title holder of the aforementioned plot of land. The learned counsel for the accused submits that the accused was arrested on 11/12/2023, and since then he has been languishing in jail for plus 30 days, and that there is no whisper in the FIR against the present accused, and the accusation in the FIR is against his wife only, and that he is ready to cooperate with the investigating agency, and therefore it is contended to allow the petition. On the other hand, Mr. R.J. Borua, learned additional
B.
PP
Sharma.
submits. On the B. Sharma, learned additional PP has produced the case before this court and submits that the IU has collected sufficient incriminating materials against the accused. And the statement of the co-accused, that is Mrs. Bijoya Dotto Soikia, the wife of the accused, indicates that she entered into agreement with the informant to sell the plot of land as per direction of her husband, that is the present accused. Though the accused is languishing in jail as it for last 30 days, yet having regard to the nature of accusation against the accused and the modus operandi adopted by him in defrauding the customers, this court is of the view that this is not a fit case where the privilege of bail can be granted to the accused. Accordingly, the petition stands dismissed. Case will be returned.
28. Item 28.
Non-appears for the accused on call is the matter after petition.
29. After which?
After that.
After view only.
Yes, your lordship.
Yes, Borua case received here.
Yes, my lord. Yes, there is.
26 days in detention.
Yes, what is your case?
My lord, 26 days in detention. Page 8 is the
How many days?
26 days, lordship. Page 8 is the affair. May I read the contents, lordship?
Page number?
8, lordship.
Yes, Borua.
My lord, he was caught, lordship, while trying to access the ATM card, lordship. Then public came, lordship, public gave him Dhulai. Then he was my lord, handed over to police, lordship.
Hmm.
That is the allegation. That is the my lord, material, my lord, in the case. He is from UP, lordship.
UP.
UP.
So what is the stage of stage means investigation might have been completed in the meantime.
Investigation completed, a matter of Caesar has been made, lordship, and statement recorded, lordship. He was, my lord, already, my lord, arrested on the same day.
Whether custodial interrogation detention is required? I think not
Already, my
required.
lord, sufficiently progressed, lordship, what I found from.
Heard Mrs. T. Sung, learned counsel for the accused, and also heard Mr. R.J. Barua, learned additional people for the state respondent. This application under section 439 services prepared by accused Sonu Kumar, who has been languishing in jail as in connection with Hazu PS case number 420 of 2023 under section 420. No, 7/20/2023 under section 420, 379, 511 IPC. Be it noted here that above noted case has been registered on the basis of one FIR lost by one Forest under Malakar on 16/12/2023. The allegation against the present applicant is that on 16/12/2023 at about 1:50 p.m. when the informant attempted to withdraw money from SBI ATM located near Domdom Asok, then one person taken his card, ATM card, and he changed the same and thereafter he tried to flee away, and then he got hold of the person and handed over at the police station. The learned counsel for the accused submits that the accused has been languishing in jail as of for last 26 days. And that the case has been registered under section 420, 379, 511 IPC, and the investigation in the meantime might have been completed, and as such, his further custodial detention may not be required, and therefore it is contended to allow the petition. On the other hand, Mr. Borrow, learned additional PP, has produced the case there before this court and submits that the IOS collected sufficient materials against him. However, Mr. Borrow submits that the investigation has progressed sufficiently. For having heard the submission of learned advocates of both sides, I am going through the petition and the documents plus on record, and also peruse the case diary with the assistance of Mr. Borrow, learned additional people. It is no, the case diary indicates that the accused was arrested on 16/12/2023, and since then he has been languishing in jail. The case diary also indicates that material part of the investigation is almost over. Then, in the interest of investigation, further custodial detention of the accused seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with one security of like amount to the satisfaction of the learned JM first class Hazu, the accused BM Larson.
Deep topics.
Not again. 30. 21 I will say. 25. Yes.
Your Honor, item number 7 and item number 8 are both linked together. And this case is related to a very prominent area in Guwahati, Hatigaon area, where human trafficking, prostitution, and those things are being carried out with the help of the Hatigaon PS. And my petitioner is a victim of the whole game. Although she used to reside in Boko, these activities are being carried forward by her husband.
No, you see this criminal petition number 12.
Yes.
Here the sections under which the case has been registered is 384/506 and 67 IT Act.
Yeah, that is linked to the case that is item number 13, Your Honor, where in which that's the next one, where he had launched a FIR claiming that his pen drive was stolen, which actually he claims happens to be the evidence because she had filed a case with the
Where is the
Hatigaon.
FIR?
That's page number of the item 13, page number 61.
No,
and
in this
67.
petition, where is the FIR? Petition number 12.
71, page number 71, annexure 9.
No, in this petition, you want to
Quash the
FIR of
say, the 261.
261.
Number
And
261,
which is the FIR?
2022. And this is that needs to be quashed. And
Page number 20.
page number 71, annexure 9.
71 is the FIR lodged by this petitioner, it's herself.
That is criminal petition number 12. 71 is my page number and annexure 9. You know, if my
Here the petitioner is Jasmina Parveen. And the FIR is also lodged by Ms. Jasmina Parveen. And the petitioner want to was the FIR lodged by herself. Is it your case?
There's a small no, up to Satar. There's a small typing error.
Where?
In page number 72, a
You
small
corrected
typing error.
on the
but,
pair being made by Ms.
73,
So-and-so.
page number 73 is the
Always
complete
raised it to list the matter after vacation so as to enable the petitioner to make necessary correction in the petition.
Item 8.
Number 8.
Item 8.
Item 8. Here the annexure 7, page number 61.
What is your name?
Is Saikia.
Heard Ms. Soike, learned counsel for the petitioner, and also heard Mr. Biswarma, learned additional treatment for the state respondent. In this petition under section 482 SRPC, the petitioner, Mrs. Jasmina Parvin, has rightful closing the FIR number 490 of 2021.
She's also charge sheeted in this matter, Your Honor. Actually, her name was not mentioned in the FIR, but it was included in the charge sheet.
Have you challenged the search it here?
Yes, the copy of the charge sheet is also included.
And the FIR dated 490 of 2021. And the
The
search it
LCR
dated
maybe, she never received a
search
summon
it
about it.
number.
She never
Please,
received.
please don't disturb at the time of
Right.
dictation. Search it number 264 of 21. Dated 31/12/2021. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Abdul Sattar on 19/9/2020. Where is the petition and the documents placed on record? Let notice be issued to the respondent.
Right.
Returnable in 4 weeks, that be taken by registered post and also the usual process within a week from today. No formal notice is required to be issued to the respondent number one,
Right.
since Mr. Disarno learned additional PP appears and receive notice. However, extra requisite copy of the petition be furnished to him during the course of the day. Registrar shall call for the scanned copy of the record. In which court the case is pending now?
The LCR, actually because she never received a summon, the sessions court,
Session court.
yeah, not CZR.
We have enclosed the search sheet here.
Annexure 9. The translated copy is page number 75.
SSL call for the scan copy of the record from the learned court below, list the matter along with the case diary. List the matter after 4 weeks.
Right.
Timing item 2.
May I please, Your Lord?
Yes.
Right, take your Lord to the FIR, my Lord. Kindly come to 11, my Lord. To the WD message, my Lord. And accordingly, a CR case was registered. And next page, your Lordship will find the forwarding report, my Lord. The allegation is that they have entered to the reserve forest area. Actually, my Lord, there is a tea garden adjacent to this Burapahar range, my Lord. They had to pass through that area. And the allegation is that 2 pieces of Segun Patam was found. And 53 days already completed, my Lord.
Yes.
Lordship, he was arrested on 19. We seek some time for the final offense report. Lordship may fix it before the 19th of this month. We will produce the final offense report.
If it is 19th, my Lord, it will be over than 60 days, my Lord. Steady repeat is 60 days. Maximum punishment is.
Or Mr. S.C. Biswas. No, perhaps there was some amendment.
No, my Lord, I am speaking on the amendment.
So
Latest book
punishment is perhaps more than 7 years.
I have got the latest books, my Lord. It is 2000, of course, I don't know, 2017 edition. It is.
No, this Assam amendment is there.
Yes.
I'll find out.
Is it available with you?
Even after 7 years also, it is 60 days.
Pardon?
Even if punishment is after 7 years or in the 6
No, no, more than 7 years. After the new amendment.
Lordship, there is a provision for life imprisonment,
No, no, no.
but
Yes.
that is for second offense.
Second.
Right now,
And,
Lordship, it is 60 days.
It is 60 days. Because I have entered to the forest, Delhi area, we have trespassed to the forest area.
But Lordship,
Not killing any animal
final offense report will have to be perused. Lordship.
within 60 days.
Heard Mr. S.C. Learned Counsel for the accused, and also heard Mr.
I Bhattakur,
Bhattakur, Learned Counsel appearing on behalf of Mr. D. Gogoi,
Special D. Gogoi.
Learned Standing Counsel for the Forest Department. This application under Section 439 services prepared by accused Norris Gonzo and Hiren Gonzo, who are languishing in jail as in connection with
BR case number, that is Burakapuri range matter.
pardon?
BR case number 9.
BR case number
9 of
2023 under section 27, 29, 31, 50, 51 of the Wildlife Protection Act 1972 and under section 33, 34, 35, 40, 41, 49 of Assam Forest Group. Volume 8, Volume 7, 1891. It is to be noted here that above noted case has been registered on the basis of one report. Report or WT message?
Yes.
On the basis of one WT message issued by one Goisaklang Kamai, investigating officer of Burapaharans Ghodakati on 19/11/2023. The sense of allegation made in the aforesaid message is that on 18/11/2023, when Norris Gonzo and Dhiren Gonzo entered into the Baksar Reserve Forest under Kaziranga National Park and Tiger Reserve and felled the trees of the reserve. Mr. Biswas, Learned Counsel for the accused submits that the accused were arrested on 19/11/23. Is it correct?
18
18 or
19
19?
I'm saying.
19, and since then they are languishing in jail as well, and that the mandatory period of detention here in this case is only 60 days. And there is no allegation of killing any animal in the reserve forest. And the allegation is only about felling of trees. And that they are ready to cooperate with the investigating agency, and therefore it is contended to allow the petition. On the other hand, the Learned Counsel appearing on behalf of Mr. D. Gogoi submits that the Forest Department will be filing offense report very soon, and the same may be called for. Having heard the submission of learned advocates of both sides, I have gone through the petition and the documents placed on record. And it appears that the accused are arrested on 19/11/2023, and since then they are languishing in jail as well. For last 53 days.
Yes. 53 days.
53 days. In view of the nature of accusation and the punishment prescribed for the same, and also in view of the submission of learned advocates of both sides, further custodial detention of the accused person seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 each with one surety of like amount to the satisfaction of the learned Subdivisional Judicial Magistrate within bracket M Koliabor. Both the accused be enlarged on bail. In terms of above, there should be a disposal.
Pending item 16.
Yes.
FIR at page 12. Paragraph number 4 is allegation against the petitioner. That the petitioner has caused one power of attorney in the name of the informants. At page 15 of the
1-5.
yes.
Page 15 is the FIR.
Page it starts from 12. Fifteen is after it starts from here. Paragraph 4 is allegation against me. Page 16. I know much and good. What the informant has concealed, Your Worship. That is, the agreement entered with me at a consideration of 60 lakhs. Your Worship will find the agreement at page 21. And by execution of this agreement, they have received 5 lakhs rupees on 1st day of April 2023. At page 22, Lordship will find the second paragraph. The enter between the informants and Umashankar. And another important fact they have concealed in the FIR, that is, they have in fact received 30 lakhs rupees.
From you?
Yes. And fortunately, Your Lordship, after the filing of the FIR, the next day they have filed a civil suit. Lordship will find the paragraph 2 of the plain. They have themselves admitted. Page 27, Lordship will find. The FIR was dated 12/12, and prior to that, on 11/12, they have filed the suit for cancellation of power of attorney, sale deeds, etc. And these informants, I am arrayed as defendant number 1, Umashankar Dev, page 27. And Lordship, have a kindly have a glance at paragraph 2 of the plain, page 30. They have admitted here in Your Lordship that the agreement was entered into between me and the informants, that is the plaintiffs. And they have received an amount of 31 lakhs 10,000.
So there's a title suit was instituted for cancellation of this power of attorney.
Power of attorney. No.
So allegation in the FIR is that her signature was first.
I have paid 30 lakhs rupees, 31 lakhs rupees. Possession was delivered. Now this, they executed the power of attorney.
Possession was delivered to you.
Yes. And I paid the substantial amount, 31 lakhs, admittedly. Unless this plaint has been filed by them, Your Lordship.
Where it is admitted that she has received sum of rupees 31 lakhs.
Paragraph 2, Lordship will find of plaint, page 30.
Yes.
Middle portion, Lordship. Defendant number 1, Sri Umashankar De, has paid an amount of rupees 31,10,950 only through check, in cash, and through online transfer from various accounts on various dates to the plaintiff till 24/4/2023.
Then why she has filed that?
Yes, that just to pressurize me. Now the price of the land is high. Now I have paid the money. Now she has bargaining with me, the plaintiffs. When I refused, they lost this affair. And all the subject
Yes.
matter of the trial, Your
Yes,
Lordship, was
Mr. Loskor,
it's absolutely civil
what is
suit.
this?
First of all, Lordship, the Lordship disputed power of attorney that is not annexed here with Lordship. So we cannot say whether what is there in the power of attorney. And secondly, Lordship, the allegation in the plaintiff Lordship, that is page 32, that is the allegation which is in the FIR Lordship, that they never put their signature in the power of attorney. Here may be some agreement out of 60 lakhs, they may get 30 lakhs, but they are now saying their allegation is that they have not put any signature in the power of attorney.
But
If that is
subject matter of the civil suit.
No, no,
How
no,
could the
subject.
This is subject matter of the civil suit, Your Lordship.
Let him complete.
Lordship, the main thing is the Lordship, why they did not annex the power of attorney.
No, Mr. Lockor, you see the FIR and the signature therein, and thereafter you see the title suit.
Lordship, that's a paragraph 3, Lordship. FIR paragraph 3, Lordship. That's after we applied for certified copy of the sale deed bearing number so and so, Lordship, for the year before the office of the sub-registrar Tinsukia, and after obtaining the certified copy of the sale deed, we astonished that surprised that Umasankar they fraudulently executed the aforesaid sale deed through a fraudulently. That means there may be one thing, Lordship, that there was a 60 lakhs, it was agreed, 30 lakhs they paid. Thereafter, that without paying that 30 lakhs, Lordship, they may execute a forced power of attorney. On the basis of that, they may sell it. So, Lordship, at this stage, Lordship, let the CD come, Lordship, because Lordship, that sale deed was made on the basis of that power of attorney, Lordship, and that power of attorney is forced as per their statement, Lordship. Sale deed has been executed already. Then if they are saying that,
No, but it appears from the title suit that some transactions are there between the accused and the informant.
because of the transaction, that cannot be said, Lordship, there is no any criminal intimidation, Lordship. When there is a criminal intimidation, there it may be civil, Lordship, but that part will come separately, Lordship, because they have put their signature. They did not. They said we have not put our signature in the power of attorney, and on the basis of the power of attorney, title should executed, Lordship.
So where is that
power of attorney? Sale deed executed, Lordship.
Mr. Dotto, where is that power of attorney, which is allegedly false here?
That they have filed in the title suit, Your Lordship.
What
I want to say, Lordship, that the power of attorney, sale deed, cancellation, validity, everything is the subject matter of the civil suit. Everything, Lordship, once the civil suit is filed.
No, that's all right. But here the allegation is that they have the applicant has forged the power of attorney. Where is that power of attorney?
Power of attorney is they filed in the civil suit, because only do we receive the copy of the plaintiff, Your Lordship, that we annexed.
No. Can it be believed that without enclosing the documents they have filed the?
No, they have filed. They have filed.
Then
I'm told that they have filed the copy of the power of attorney. They have filed the sale deeds
okay,
copy.
Mr. Dutto, you do one thing.
Lost.
You produce that power of attorney.
We absolutely
will consider you fair.
Lost.
Not today.
Lost.
Okay, as agreed by learned advocates for the applicant, list the matter on when will we able?
After that, because it's too tough. After vacation.
Vacation. Okay, on
18.
18. So as to enable him to produce the alleged power of attorney. No, to produce the power of attorney which is allegedly forced by the present accused, the present applicant. List accordingly.
18 years.
18.
No, grateful. Timing under 50. Timing under 50.
My lord, I have received the information, my lord.
Yes.
From the concerned office, OC, my lord. Here, my lord.
Whether any case
No,
is there, sir?
no case.
No case. Okay, heard Mr.
Yeah,
A. Ali, learned counsel for the applicant and also heard Mr. P. Sharma, learned additional PP for the state respondent. This application under section 439 CRPC 438 services prepared by four applicants, namely Ibrahim Ali, Rafiqul Islam, Rasidul Islam, Usman Ghani, who have been apprehending arrest by police of Goalpara police station in connection with any FIR pending before the said police station. It is to be noted here that by order dated 14/12/2023, the learned additional PP was asked to obtain a report from the officer in charge Goalpara police station as to whether any FIR is pending or whether any case has been registered against the present applicants in Goalpara police station. Pursuant to the said order, Mr. B. Sharma, learned additional PP, has produced one report today, furnished by the officer in charge Goalpara police station. Perusal of the report indicates that no case has been registered against the applicant in Goalpara police station. In view of above, this petition is found to be infractious and accordingly the same is dismissed.
Timing item 51.
But here also we have received the information.
So what is the information
No
received
case.
here?
No case.
No
No
case.
case pending.
Person to order dated 22/12/2023, Mr. B. Sharma, learned additional PP, has produced a written report received from the officer in charge JRD, Zagirud PS, Zagirud PS, wherein it is indicated that no case has been registered against the applicant Lazu Ahmed at Zagirud PS. It is to be noted here that this application under section 438 CRPC is prepared by applicant Razu Ahmed, who has been apprehending arrest in connection with any case registered with the Zagirud PS under section 468, 471, 428. Since in view of the report in view of the report of the officer in charge Zagirud police station, no case has been registered against the present applicant. The application filed by him become infractious and accordingly the same stands dismissed. The report.
Kept as a part of the record.
The report submitted by Mr. Sharma shall be part of the record.
Import the of that.
Timing item 20. Instruction was from the procedural.
We have contacted him at the concerned police station also. They said they have not received any notice.
The problem is that 85 days lordship behind the bar. The problem is that 85 days behind the bar.
That's all right, but without hearing the other side, this is POXO case.
My lordship.
Heard Mr. M. Khan, learned counsel for the accused, and also heard Mr. RJ Bora, learned additional PP for the state respondent. Mr. Khan submits that step upon respondent number 2 was taken to the officer in charge Mankasar police station. And pursuant to the order of this court dated 7/12/2023, the learned additional PP has to submit a report regarding causing service of notice upon the respondent number 2. Accordingly, while the matter was taken up during the first half of the session, Mr. Borua learned additional PP praised for taking up the matter at 2 p.m. And while the matter was taken up in the second half, Mr. Borua submits that as per his instruction, police has not received any report, no received any notice for causing service upon respondent number 2. Under the aforesaid facts and circumstances, it is provided that the learned counsel for the accused shall take fresh step upon respondent number 2 by registered post and also by usual process and also through the officer in charge jurisdictional PS. List the matter on 18. In the meantime, the learned additional PP shall produce the case diary before the court.
Standing item 22.
The 22 also received, we could not contact the investigating officer received, along with the OC also received.
Otherwise, also, my lord, the petitioner has completed 50 days in custody, my lord.
200?
250 days. And my lord, statement of the victim has also been recorded, my lord.
Victim examined, Lord, sir.
During trial?
Yes, my lord. Out of 11 witnesses, my lord, 3
That's
witnesses.
all right, but without hearing the other side, if we pass the order, it would amount to a nullity. Problem is that. Mr. R.J. Borua, learned additional PP, submits that though he was asked to confirm from the officer in charge concerned PS regarding service of notice upon respondent number 2, yet he could not contract with the concerned officer in charge. Accordingly, it is provided that learned counsel for the accused shall take fresh step upon respondent number 2 by registered post and also by usual process within a week from today. And also through the officer in charge jurisdictional PS. Registrar list the matter on when?
25, let it be on 22nd.
22nd. Okay.
Highly obliged.
You take a step, if
Fine.
possible, today itself.
Standing item 24.
I have gone through the record, Lordship, LCR, Lordship. LCR, his statement is 161 not here, Lordship, but the in CS, Lordship, that is annexed with the petition, Lordship. His allegation is there, Lordship. What is there? That is page 71 of the petition, Lordship.
71.
71. 15.
No, the search has already been framed. Only one witness has been examined perhaps. So how many witnesses cited in the search?
56.
Pardon?
56.
56. So the ground for granting bail in the other case was that if the prosecution takes so much time to examine only one witness, then it will take several years to examine the 56 witnesses. That was the ground.
Otherwise, Lordship, his allegation and others other accused person who are in who has been released on bail, Lordship. Allegation is same, Lordship. I have checked, Lordship. Other 3 persons.
Allegation is same.
Lordship.
No, in that order, we have not dealt with the merit of the allegation.
As his statement is not here, Lordship, so we cannot say, Lordship, what.
Pardon?
As his statement is not here next to the LCR, Lordship, has not come LCR. So we cannot say more than this, Lordship. 15, para 15.
No, say the note in the search sheet was prepared on the basis of a statement made by the witnesses. So
this is the summary.
It was a summary. Whether that statement is available with him.
actually, these persons' statements are not available. Only earlier who named in the FIR, their statements were available, Lordship. So that is why, Lordship, we are not married right now. This is the
Is this the second bail application here?
no.
First application. Okay. We reserve the order. We see the search it. Heard Ms. S. Nagis, learned counsel for the accused, and also heard Mr. T.S. Locker, learned additional PP for the state respondent. Argument concluded. Order reserved.
My only condition is that, Lordship, 56 number, same contention which has been, Lordship, stipulated there.
We'll say.
Coming item 25.
My lord, in this case, charges submitted.
Charge sheet submitted. Charge sheet under section
21B, Lord.
NDPS Act.
My lord.
He has been languishing in jail as of for
55 days as on. 55 days.
55 days. So here the quantity is intermediate quantity. And as such, the embargo under section 37 of the NDPS Act will not come into play.
Not 37.
Heard, Mr. M.I. Hussain, learned counsel for the accused, and also heard Mr. R.J. Borua, learned additional PP for the state respondent. This application under section 439 CRPC is preferred by accused Ali Hussain, who has been languishing in jail as in connection with Bangladesh PS case number 492 of 2023 under section 21B stroke 29 of the NDPS Act since 17/11/2023. Be it noted here that above noted case has been registered on the basis of one FIR lodged by SI Sukesh SI Sukesh Ghosh on 17/11/2023. The allegation level in the aforesaid FIR dated so and so is that on on 17/11/2023, acting on a tip of, they have apprehended one person, namely Sukesh Ghosh, inside the motor goda. What is motor goda?
Please, Lordship.
And recovered suspected heroin weighing 71.31 grams along with container. The learned counsel for the accused submits that the accused has been languishing in jail as of for last 55 days. 55 days. And that the quantity of contraband substance allegedly recovered from his possession is of intermediate quantity. And as such, the embargo under section 37 of the NDPS Act would not come into play here. And that he is ready to cooperate with the investigating agency and would appear before the learned court below, and therefore it is contended to allow the petition. Whereas Mr. R.J. Borua, learned additional PP, obtaining instruction from the officer in search concerned PS, submits that investigation of the case has already been completed and the IO laid charge sheet against the accused, being charge sheet number
01 of 2024, dated 7/1/2024, under section 21B NDPS Act.
Admittedly, the quantity of contraband substance recovered from the position of the alleged position of the accused is of intermediate quantity. And as such, the IO has laid charge sheet under section 21B,
My lord.
stroke 29 NDPS Act. Since the quantity of contraband substance is intermediate quantity, the question of the embargo under section 37 of the NDPS Act would not come into play here, and that the accused is languishing in jail as of for last 55 days. And balancing the same with the nature and gravity of the offense, this court is of the view that his further custodial detention may not be required in the interest of investigation. And accordingly, it is provided that on furnishing a bond or with 50,000 with one security of like amount to the satisfaction of the
Special Judge Bongaigaon.
Special Judge Bongaigaon, the accused be enlarged on bail.
Since charge sheet submitted, notice of my submission may be recorded.
Dictated already.
Obliged.
The number 30.
Legal lordship. So this is a 439 application lordship. And allegation is under section 379 lordship. And petitioner are behind the bar for last 34 days lordship. FIR is at page 8 lordship. There the petitioner are not FIR named in this lordship.
Is there not received lordship?
Is there not received? But the accused is 34 days.
They are not FIR name issues lordship.
Hmm?
Merely they were arrested merely on suspicion lordship.
Where is the forwarding report?
Forwarding report is at page 16 lordship. They were arrested only on the ground that lordship mandate prayer number 6. The petitioner number 2 has some previous criminal incident lordship. That is why they were arrested.
And 2 numbers of bike keys was recovered from their possession.
Although 2 numbers, but I have annexed the seizure list lordship. There are only the 2 numbers keys of 2-wheeler vehicle, but no independent signature is there lordship. The seizure list.
Oh, let the city come. I will fix it sorted. Because without any bike, you did possess 2 keys.
But the key lordship, the petitioner
Why?
number
Why?
2 key were recovered lordship. Here I have annexed the seizure list lordship. Here only signature of petitioner number 2 is there. No independent witness. Wherefrom it is recovered, that is not mentioned in the seizure. Page 18 lordship kindly. Because of he petitioner number 2 had some criminal antecedent lordship. Both were arrested lordship in connection with this case lordship. Merely on suspicion.
No, the thing is that 2 numbers of keys were seized from their position. Maybe there may not be any independent witness.
The forwarding report.
But where is the point for disbelieving the investigating officer?
Because in the
In respect of the seizure of the keys?
the forwarding report, lordship, the main.
No, it is stated that they are strongly suspected.
Yes, they found loitering in the GMCS campus.
And your antecedent is also not good. One Dispur PS case number.
Respect of petition number 2, Lordship. One is, there is nothing mentioned about one, Lordship.
Okay, 18th.
My lord, 18 Lordship.
Mr. Arzaburu, learned additional PP submits that he has not received the case ID and press for granting some more time. They are allowed. Place the matter on 18. Yeah. 18, 19. 19.
32. 32.
My lord, this is for 39 application, my lord. We are behind the bar since 12 days, my lord. PD was called for, my lord. Kindly for a moment, page number 8 FIR. My lord, so far the FIR 1, Himanshu Bora and Narayan Sarkar are demanded asked rupees 4,000 in the name of providing blood. And no
In the name of?
one Narayan Sarkar and Himanshu Bora. We are Rupjyoti Roy and Niranjan Mandal, my lord. In the name of providing blood, my lord.
Case there is not.
No offense made out against us. So far the plain reading of the affair.
Then how both of them were arrested?
My lord, the reason known by the IO, my lord. That because no 41A notice was served upon us, my lord. No, my lord, allegation is under section 420-487. We have not cheated anybody, not extorted anybody.
No, this
my lord,
allegations are there in the FIR. Annexer 1 is the FIR?
FIR, my lord.
Yes.
Against Himanshu Bora and Narayan Sarkar. We are Rupjyoti Roy and Niranjan Mandal. Present petitioner are my Rupjyoti Roy and Niranjan Mandal. Specific allegation against Himanshu Bora and Narayan Sarkar. No specific allegation against us. Well, this much of further custodial detention may not be required.
May not be required, but the type of business you have indulged in. Let the city come. When? 18th?
22 Lord.
This is from higher.
19. 19. Same order, Mr. Bora.
33.
Procedural, Lordship. 439 application, Lordship. Case is registered under 21B and 29, Lordship.
The case there is not received. Lordship.
Today is about 39 days, Lordship.
From which PS?
It's from Soigao, Lordship.
Okay, let the city come then. On 19th. Mr. RJ Bora, same.
Item 54.
54, 90 days complete.
90 days?
Day before yesterday, matter was listed.
Heard Mr. D. Soikia, learned counsel for the accused, and also heard Mr. Sarsit not submitted.
Sarsit not submitted. Case there is lying for us.
Mr. RJ Bora, learned additional PP for the state respondent. This application under section 439 services preferred by accused. Neeraj Kormakar, who has been languishing in jail Azut in connection with Moran PS case number 99 of 2023 under section 457, 376(3) IPC, it is section 6 of the Foxway. It's to be noted here that above noted case has been registered on the basis of an FIR lodged by one Timothy Moni Kalandi on 5/10/2023. The essence of allegation made in the FIR dated so and so is that for the last 3-4 months, one Neeraj Karmakar has committed rape upon the minor daughter of the informant aged 15 years. The learned counsel for the accused submits that the accused is behind the bar for last 90 days. Last 90 days, and no charge sheet has been submitted till date, and as such, the accused is entitled to default bail. And accordingly, it is contended to allow the petition. On the other hand, Mr. R.J. Borua, learned additional PP, confirmed that the case ID is with him, and no charge sheet has been submitted till date by the IO concerned. Why the investigation is pending?
Case that was forwarded to us on 4th of January, this month.
4th of
January.
yes.
But last entry was if the accused person is surrendered before the trial court was. The last entry.
Having heard the submission of learned advocates of both sides, I have gone through the petition and the documents plus the record and also perused the case area with the assistance of Mr. Borua, learned additional PP. It appears that the accused was arrested on 13/10/2023.
Surrendered 13/10.
That the accused has surrendered before the learned court below on 13/10/2023, and since then he has been languishing in jail as well. Further, it appears that no charge sheet has been submitted till date, though 90 days has already over. In view of above, this court is of the view that the accused is entitled to default bail under section 167, which in bracket 2 of the CRPC. Accordingly, it is provided that on furnishing a bond of ₹50,000 with one surety of like amount to the satisfaction of the
Additional session does FTC Dibrugarh Lodge.
to the learned special judge Oxo Dibrugarh. The accused be enlarged on bail. Case will be returned.
Item 34.
413 application lordship, case that was published because I am on interim lordship.
We have not received the case.
You are on interim. Mr. R.J. Borua, learned additional PP. Borua, more than 7 years elapsed. No, 7 months elapsed since the registration of this petition. Heard, Mr. Learned counsel for the applicant and also heard Mr. R.J. Borua, learned additional PP for the state response. Apprehending arrest in connection with
The forest department is appearing in this case.
who?
It is mother, our name has been shown, the state of Assam.
Have you served copy upon the respondents? Forest department?
Actually, I am appearing on behalf of SM Abdullah lordship. So I'll inform the forest department lordship.
So as agreed by learned counsel for the counsel for both the parties, release the matter tomorrow. Till then, interim order pass earlier shall continue. Mr. Borua, kindly inform Mr. Gogoi.
But Gogoi he has not come today. I have already.
And rest shall reflect the name of standing counsel for forest department in the constellation.
Be recorded as the
Pardon?
KP Pathak's name may be recorded as the forest.
KP
Standing
Pathak.
counsel for forest.
KP Pathak.
KP Pathak. Okay, KP Pathak. Baro. Okay, 12. 12.
35.
May it please your lordship. My lord, in this case, my lord, the CD, uploaded CD was called for. And my lord, the notice was sent to the informant, my lord. And I understand, my lord, the informant has already appeared. His name has also been shown in the call list, and also they have filed an affidavit. And my lord, this is, my lord, in fact, my third application, my lord. The first application was rejected, my lord, and thereafter, my lord, second application was filed. And the second application was held to be not maintainable, my lord. And thereafter, the third application has been filed on the ground that no ingredients under section 376 have been meted out. So on that ground, my lord, the honorable court was satisfied. And thereafter, my lord, the city was called for and the notice was sent to the informant, my lord. And accordingly, informant has appeared, they have filed an affidavit. And in their
Yes, that CD is available.
CD available, lordship, but lordship, what I found in the CD is not up to date.
Since when?
Since 22, lordship. Last it was up to date on 29 2022.
29 of?
At 22, lordship.
And in
What's
fact, my lord, in our petition, my lord, we have said how this FIR has been filed. And my lord, the stand taken by the. And my lord, the
lord,
stand,
it is,
and stand taken by the, my lord, the.
Oh, whether the statement of the victim girl is available?
Yes, lordship, 164 statement, 161 statement is
Available.
just, yes, statement of the witness also available.
So why the case has not been started?
This question I have to.
And why the case that is pending here since 2022?
Yes, lordship, last it is updated 30/8/2020 from the case diary what I.
Oh, why it is pending here then?
Yes, lordship.
My lord, the FIR has been lodged, my lord, after 1 year of the occurrence, my lord. LS occurrence, my lord. That was
Maybe
made after
there
1
is an
year.
explanation for the delay, then it doesn't
There is
matter.
no explanation, nothing of the sort, my lord. Explanation has been given.
But
after 40
that
days.
has to be again examined by the trial court during trial, not at this stage.
And moreover, my lord will find, my lord, stand taken by the informant, my lord, in their affidavit, my lord will kindly go through their affidavit, my lord. The informant himself has said, my lord, that he has been misled. He has been misled to file the FIR, my lord, this false FIR. That is an admitted position by the informant himself. In fact, my lord, we have stated in our petition that there was some land dispute between us, between the parties. And
But
subject with a-
Mr. Chaudhary, you see, in her there is observation of this court
my lord,
in the order dated 6/9/2022
my lord.
that the victim in her statement under section 161 as well as under section 164 CRPC have implicated the petitioner. That is the observation
My
of
lord,
this court.
their observation is there, because in the first application, my lord, there are main stories have not been disclosed in the petition, my lord. That also we have said.
After
in our
this
third
observation, whether this court can again examine whether there is ingredients of the offense under section 376 or not. That is the question.
My lord, my lord,
Is there
says, my
is
lord,
there any
in-
change of circumstance in your favor after rejection of this first
change of
application or second
circumstances,
application?
my lord, if my lord will go through the FIR itself, my lord, FIR goes to show that there is no ingredients of 376, my lord.
No, that has already been considered by the court
And also, my lord,
in first and second application.
and it says, my lord, FIR reveals the allegation. But where is the allegation, my lord? FIR does not say any allegation, my lord, for committing rape, my lord. And also, my lord will find the person, my lord, who lost the FIR, he is now before your lordship. He says, my lord, that he has been misled by some of the villagers to lodge this FIR, my lord,
So
in order
where
to
is
grab my property.
before whom he made such a statement?
Before
Where is
this
that
court-
statement of the
My lord,
informant?
your lordship will find the right on the record, my lord.
My lord, I
In the
have filed
affidavit.
this affidavit.
Pardon?
My lord, I filed this affidavit on behalf of the informant.
Ah.
For number two, he
Yes.
received for the first time.
From this side.
My lord, after receiving the notice, my lord, he has appeared, he came to my chamber, my lord,
Mm.
and he has stated some facts which I have recorded in my mobile, my lord. Then I have filed this, lodged this, my lord, filed this affidavit.
Mm.
Where paragraph 2 of this, my lord, affidavit, may I kindly peruse.
Paragraph number 2.
2.
Hmm. Yes.
May I read, my lord? That
Yes.
one Hafizur Rahman, who is a resident of about 1 kilometer away from the residence of the deponent, has compelled this deponent to lodge the FIR against Abdul Mannan. This is due to some ill intention to grab the money and land from the accused Abdul Mannan, and hence the FIR was lodged.
We'll fix it. Until then, we will extend interim this protection.
Money.
Heard Mr. S. A. Ahmed, learned counsel for the applicant, and also heard Mr. P. S. Locker, learned additional PP for the state respondent. Apprehending arrest in connection with Governor PS case number 58 of 2023 under section 353 IPC, read with section 22B/29 of the NDPS Act. This application under section 438 service is prepared by applicant Sirazul Haq for grant of the privilege of years bail. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by one. Where is the FIR?
FIR, my lord, at case 17. 17.
SI,
It's a long FIR.
SI will do.
SI Abhijit Gogoi of Abhijit Gogoi, OC Gaurabanda, Govardhana PS. The essence of allegation made in the FIR dated so and so is that acting on a tip of on 6/2/2023 at about 10:10 p.m. Conducted nakaseking. And apprehended 2 persons. At NH31 in front of Simlaguri PP. In one Baleno vehicle. Namely Mohammad Inamul Haq and Mohammad Bilal Hussein.
Another is Isham Yaman. 3 persons were
Samia Bilalusen
And also apprehended one Bisa Mia while he was trying to flee away by snatching one gun from a constable. And one accused, namely Sirazul Haq, managed to flee away. And recovered one plastic packet containing 10.62 grams of psychotropic substance. And in another plastic packet, another 10.59 grams. And in another plastic packet containing 20.65 grams. And 7 plastic vial containing suspected psychotropic substance weighing 1.22 grams. The learned counsel for the applicant submits that the total quantity of contraband substance allegedly recovered from two accused was of, what was the total quantity?
53.08 gram.
53.08. And the same is of intermediate quantity, and as such, the embargo under section 37 of the NDPS Act would not be applicable here in this case, and that the present applicant is innocent and no way involved with the offense alleged, and that he is ready to cooperate, ready to face trial. Further, learned counsel for the applicant submits that after completion of investigation, the IO has laid charge sheet against the present applicant, showing him as absconder in the charge sheet. And that he will appear before the learned court below on each and every date, and therefore it is contended to allow the petition. On the other hand, Mr. E.S. Locker, learned additional PP, submits that the present applicant is the main culprit who managed to flee away at the time of checking, and that the case has already been charged after completion of investigation under section 21B. No, under section 353 IPC, rated section 22B stroke 29 NDPS. Having heard the submission of learned advocates of both sides, and also considering the fact that investigation of the case has already been completed and charge sheet has been submitted under section 353 IPC, rated section 22B stroke 29 NDPS Act, this court is inclined to dispose of this anticipatory bail application by directing the applicant to appear before the learned court below and to apply for regular bail. In the event of filing such an application, the learned court below shall consider the same in accordance with law. Within COVID.
Next date is
29. On 29.
my lord, next date is fixed on 2/2/2024. 2nd of February.
Okay, on or before next
time code.
next is that
24.
2/2/24.
2nd of
24.
February 20.
And having regard to the submission of learned advocates of both the parties, and also considering the facts and circumstances on the record, it is provided that in the event of arrest of the applicant, he shall be released on interim period bail till next date.
Second February.
Till his appearance, lordship, otherwise, lordship.
On his executing a bond of rupees
Till his
50,000 with one security of like amount to the satisfaction of the arresting authority. The above privilege is however subject to the following 3 conditions. Number 1, that he shall appear before the learned court below on that to the baki total lagai dibo. In terms of this heavy instance disposal.
Till his appearance, lordship, that may
Pardon?
be there, lordship.
Pardon?
Till his appearance, lordship, because sometimes what happen, lordship, they appear.
No, till next date.
They appear before that, and in the as there is a interim protection, they got that privilege, lordship.
Okay,
till
till
his
next
appearance.
date.
Next date or till his appearance,
Till
lordship.
next date.
So item 4. Orders, item 40, part heard.
Obliging.
Thank you, Your Lordship. Lordship, this matter has been heard in part, Lordship. On my part, I have made my submission, Lordship. Today, Lordship, I will conclude my submission, Lordship. And the petitioner has already concluded their submission. They have submitted their written argument also, Lordship. The case in hand is that they have filed this petition for quashing of the FIR, Lordship, as well as the charge sheet, Lordship. If Your Lordship remembers, Lordship, it is a case where the petitioner demanded 4,50,000 in order to pass a favorable order to the informant. Lordship, please on. FIR, Lordship, the ground they have taken is that, Lordship, no prima facie case has been made out, firstly. Secondly, Lordship, section 17A is approval under section 17A has not been taken. These two grounds are very vital for them. Thirdly, Lordship, abuse of the process of the law by the first respondent. Complaint is false, malicious, and it is based on grudge. These are the grounds that they have taken. Let me, Lordship, first reply to the first ground taken by them. Non-compliance of mandatory provision of section 17A. Lordship, what 17A says is that no police officer can investigate or inquire into any offense which was relatable to the recommendation made or a decision taken by a public servant in discharge of his official duty, Lordship. Here in this case, Lordship, what is the alleged offense your Lordship will have to look into, Lordship? The alleged offense is that of demanding bribe, Lordship. It is not a decision taken by the public servant, that is the petitioner, or any recommendation made during the discharge of his official duty. The clear allegation is that the petitioner demanded bribe amounting to rupees 4,50,000 in order to pass a favorable order to the informant. That is the allegation. Therefore, the requirement of section 17A is not at all required. Sanction previous approval is not required. And therefore, the ground taken by not enabled in law. 17A is not applicable.
Sanction is not required.
Not required. Section 17A says approval, previous approval prior to investigate the offense. That is the mandate. Previous approval is required under 17A. When the alleged offense is recommendable to the decision taken or alleged offense is a recommendation or a decision taken by the public servant in discharge of an official duty. Here in this case, Lordship, no recommendation, there is no decision. The alleged offense, what is the alleged offense, Lordship? That your Lordship will have to look into. The alleged offense is that of demanding bribe, Lordship, which falls under section 7 of PC Act, Lordship. Therefore, there is no requirement of previous approval under section 17A of PC Act, Lordship. The second ground that they have taken is that of submission, impugn sanction order. Submission, impugn sanction order. Sanction has been taken, Lordship, after due application of my Her Excellency, the President of India has accorded sanction, Lordship, in this case. So within the valid period of time under section 19 of the PC Act, the sanction is there, Lordship. And thirdly, Lordship, regarding they have relied upon a decision of the apex court Bhajan Lal. Bhajan Lal, Lordship, I am also relying. Now, how they interpret Bhajan Lal, I don't know, Lordship, but here, Bhajan Lal. Certain guidelines has been laid down regarding quashing of the FIR and charge sheet, Lordship, in Bhajan Lal, Lordship. In para 102, Lordship, Bhajan Sir's case, Lordship. May I read once again, Lordship? In the backdrop of the interpretation of various relevant provisions of the code under chapter 14 and of the principle of law enunciated by this court in a series of decisions relating to exercise of extraordinary power under Article 226 or the inherent power under Section 482 of the code, which we have extracted and reproduced above, we give the following categories of cases by way of illustration wherein such power could be exercised either to prevent abuse of the process of any court or otherwise to secure the ends of justice. Though it may not be possible to lay down any precise, clear definition, defined and sufficiently penalizing and inflexible guidelines or rigid formula, and to give an exhaustive list, myriad kind of cases wherein such power should be exercised. Number one, Lordship, where the allegation made in the first information report or the complaint even if they are taken at their face value and accepted in their entirety, do not prima facie constitute any offense or make out any case against the accused. The first criteria is that on bare reading of the affair, if no prima facie case has been made make out lordship, then this honorable can exercise their power under section 482 to quash the FIR lordship. Here in this case, if your lordship goes to the FIR, clearly a case of section 7 has been made out, which is a cognizable offense lordship. Therefore, lordship, the first ground, it does not hit by the facts of this case. Secondly, with the allegation in the first informed report and other materials, if any, accompanying them do not disclose a cognizable offense. Same lordship. If your lordship, my learned friend has already read out the FIR on the last occasion. I'll read only the relevant portion, lordship. Your lordship may kindly allow me. Lordship, FIR is at page number 172 of the document, the petition they have submitted, lordship. 172, lordship. 172
of the petition.
Of the petition, their petition. It's a volume test, lordship. Red color volume, binding volume, bound volume, lordship. Volume 1, lordship. What is the allegation? Basic allegation against the petitioner, lordship. Let us read the paragraph. Two, lordship. Did your lordship got it? Paragraph 2, lordship. Agreed with the order of additional commissioner, Central Goods and Service Tax, Dibrugarh, I prefer an appeal before the commissioner. Commissioner is a present petitioner.
You are reading 175 page number?
72, lordship. 172.
Annexure 7.
172.
Yes.
Annexure 7, lordship. Para 2, lordship.
Yes.
Para 2. Agreed with the order of additional commissioner, CGSC. I prefer the appeal before the commissioner. Commissioner is the present appellant, petitioner, lordship. Against the adjudication number so and so, dated so and so, on so and so. Hearing of my appeal took place before so and so, commissioner, on 5/5/22. However, I'm yet to get the order on my appeal. Order has not been passed, lordship. In the month of August 2022, one Sri Rajendra, who was also present at the time of hearing of appeal, telephonically informed that Commissioner Raju Shaktival wished to meet me in the above pending matter. Accordingly, I met Raju Shaktival in this office, chamber at 3rd floor, CCSA building at Kedar Road, Machkua, on 24/8/2022. During meeting, Raju Shaktival introduced me with Rajendra, who was present there, and assured me that favorable order would be passed if I would pay 4,50,000. It's a clear demand. I submitted to Raju Shaktival that I have merit in my appeal. He told me that I am required to pay 4,50,000 rupees. That is at 10% of the demand of the tax service. He further instructed me to pay the amount through the Rajendra for getting favorable order. I did not make any commitment in the matter. On 8/9/2022, said Rajendra approached me for paying of rupees 4,50,000. So there's a clear demand made out by the petitioner to the tune of rupees 4,50,000 to the informant on lordship 24/8/2022. On bare perusal of the FIR, it clearly reflect, lordship, that is case under section 7 of PCA. My learned friend is insisting one more thing before this honorable, that complaint is different thing and FIR is different thing. Please, let me, that is your submission before the court. Let me clarify. This is the first information given by the informant to the police. And if your lordship knows this very well, lordship 154 clearly says that the first in point of time, that should be treated as an FIR, lordship. This is the FIR as per my understanding of law, lordship. What is complaint? I don't know what my learned friend is submitting. Thereafter, trap was held, and thereafter in the trap, lordship, one of the
Mr. Haloy.
Lordship.
The fact is that whether you have been treating this complaint as FIR.
Yes, lordship, subsequently.
Because In the printed form, you have stated that there's a FIR dated 28/9/2022.
Lordship, this is the FIR, Lordship.
You,
and
you come
it
to
was registered,
Annexure 8.
Lordship,
Yes, your lordship, page 170.
So, in the printed form, you have referred,
I have
you have
referred this-
created the FIR
yes, Lordship.
dated 28/9/2022.
Yes, this is 28/9, Lordship.
Which one?
The first information report.
Is it 28/9? But it is,
14 September, Lordship, 14 September.
hmm.
14 September. FIR was lodged on 14 September. The informant has lodged it on 14 September 2022.
Hmm.
That is page annexure 7,
Hmm.
page number 172. And in the printed form, Lordship, after laying the trap,
Hmm.
it was registered as because CBI did not immediately register the case because they conducted a verification, Lordship. They conducted a verification after coming to know, after verifying the fact that the FIR is genuine. Thereafter,
So, trap was laid on this
28.
28/9.
28, Lordship.
Acha.
And the accused was arrested on 29, Lordship.
Hmm.
Am I clear, Lordship? Am I clear, Lordship? That apart, Lordship, they took a ground that the CBI did not carry out any inquiry, preliminary inquiry, Lordship. Lordship, they have also relied a judgment, Komen Ruhana. I am also relying the same judgment, wherein it has been stated in para 15, 17, 19, and 20 that preliminary inquiry is not a mandate, Lordship. It is merely a administrative order which is required to be looked into by the CBI in your internal process, Lordship. So it is not a mandate. Even then, Lordship, we have verified the genuineness of the FIR, Lordship. And after verifying in presence of two independent witnesses, Lordship, we came to know that the allegation made by the informant is genuine, Lordship. And therefore, we have registered the case and laid the trap, Lordship. And in the trap, Lordship, the 4 accused person, Lordship, including the present petitioner, they were all, Lordship, apprehended on 20, the main accused was apprehended on 29. Immediately in the trap, Lordship, where the bribe amount was found, it was on 28. On 28, one altogether, there are 4 accused person, Lordship. Accused number 1 is the public servant, and another 3 are they are all private person. The person who was apprehended, he is a Hawala agent, Lordship. Through Hawala agent, Lordship, they have accepted the bribe money, Lordship. The Hawala agent, namely Rajendra, he was apprehended, Lordship, by CBI, Lordship, while receiving the bribe amount. Lordship, Rajendra, Avinash, and Mahabir. Mahabir was apprehended, Lordship. He is a Hawala agent, Lordship.
Rajendra?
Rajendra, Avinash, and Mahabir. These are private person. Rajendra is the person who is associated with the present petitioner, Raju Shaktival. Through Rajendra, Lordship, the demand was directly made, as well as through Rajendra, the informant was asked to hand over the money to Rajendra. And Rajendra again telephonically informed us to hand over the money to Avinash. And again, when we rang Avinash, informant rang Avinash, Avinash told the hand over the money to Mahabir. And ultimately on 28, Mahabir was apprehended while receiving the bribe money. All these things are recorded in tape recorder lordship, which there we have recorded it, and transcript office has been also been placed on record lordship. I flag marked it. You will also will find that there is a nexus between all these 4 accused persons who are demanding bribe, and transaction of the money has been taken place to all these accused persons lordship. Mahabir is the ultimate person who was apprehended by CBI, and the telephonic conversation between Mahabir and informant, telephonic conversation between Mahabir and Avinash, telephonic conversation between Rajender and informant, as well as the telephonic conversation of present petitioner with the informant is there recorded conversation. This year we have, it is a matter of record. So from those record lordship, clear lordship, it is a cognizable case has been made out. No grounds for quashing the FIR has been made out against the petitioner. Therefore, the petition deserves no merit. It's liable to be dismissed.
Madam, you have reply,
Yes.
but today it will not be possible because I have one meeting at 4:30. So we have to fix another date. Heard Ms. Bordolo, learned counsel for the petitioner, and Mr. M. Halloy, learned counsel for the standing counsel, no, learned special PP for the CBI. List the matter on when?
On 30 Tuesday, 31, 20.
23rd.
23rd.
There are many hearing cases. 30, same thing will happen.
Ah,
On 30, there are less.
30th of January.
30 January.
30th of January.
Okay. As parted. So rest of the matters, you can take that from him.
Item 41, lordship, I is for only delay condemnation, other side also appeared.
Mal diamond.
Revision has not been numbered, lordship, if your lordship considered by IA today, lordship, the revision can
No,
be.
today, madam, it is not possible. I have one meeting there. I have to go.
Can it be on 12th, lordship, only the delay condemnation after?
12 too much matters are there.
Only condemnation of delay 700.
Maybe, but it would not be possible on before vacation. Only after vacation.
Then after